Judiciary Committee will hold its first judicial nominations hearing of the 117th Congress. Our first panel will include 2 circuit court nominees with outstanding credentials. Candace Jackson-Akiwumi, to be on taking an Illinois seat on the 7th Circuit, and Judge Ketanji Brown Jackson for the D.C. Circuit. Our second panel will feature 3 highly qualified district court nominees, Julian Niels, Judge Zahid Quraishi, both nominated to the District Court of New Jersey, and Regina Rodriguez, nominated for the District of Colorado. Senators Duckworth, Menendez, Booker, Bennett, Hickenlooper will join us shortly to join in introducing the nominees. But before I turn over to them and to Ranking Member Grassley, I'd like to make a few points about this historic day for the Biden administration. Looking at this slate of nominees, I'm struck that they not only bring qualifications that are extraordinary to this next level of achievement, but also demographic and professional diversity. We need it on the federal bench. I'm reminded of what President Lyndon Johnson said when he nominated Thurgood Marshall to the Supreme Court in 1967. Mindful that he just sent up the nomination of the first African-American Supreme Court justice, President Lyndon Johnson said that Marshall, quote, has had a distinguished record as private counsel and as government counsel in the courts of the land. I believe he's already earned his place in history, but I think it will be greatly enhanced by his service on the court. Johnson continued, I believe he earned that appointment. He deserves that appointment. He's best qualified by training and by very valuable service to the country. I believe it's the right thing to do, the right time to do it, the right man in the right place. Importantly, he closed with this admonition, I quote, I trust that this nomination will be promptly considered by the Senate. Well, I would say, if I could, to President Johnson, a lot of nominees wish the very same thing. Surveying these 5 nominees, I believe that they are qualified by training, have distinguished records, they're the right nominees to fill these vacancies, and they've earned and deserved these appointments. All 5 of these nominees are people of color. They also come from a range of professional backgrounds. All five received well-qualified ratings by the American Bar Association. Both circuit court nominees are former federal public defenders and will, as a result, bring that perspective and experience that is far too often missing on the bench. And that's not a partisan point of view. In fact, scholars at the Cato Institute, hardly a liberal bastion, have highlighted the critical importance of adding more public defenders to the ranks of the judiciary. Today, we're on our way to doing just that. Today's district court nominees likewise represent a depth and breadth of experience that will serve them well on the bench, and that will in turn serve the people of New Jersey and Colorado. This district court panel includes Julian Neals, an expert in municipal law and a dedicated public service, who presided over more than 6,000 cases in the Newark municipal court system. Judge Zahid Qureshi, a decorated military veteran, federal magistrate who, if confirmed, will be the first American Muslim to sit on an Article III court. Regina Rodriguez, a path-breaking former chief of the Civil Division in the Colorado U.S. Attorney's Office, whose mother's family was interned during World War II in one of our nation's most shameful moments. And while this breadth and depth of experience is important, so too is the confidence we can have that all these nominees, once confirmed, understand their responsibility as judges. It's a welcome change to see nominees who've been selected for their credentials and abilities, rather than those who've simply checked a box in their political experience. For 4 years, President Trump nominated and Senate Republicans approved far too many nominees, many of whom never should have been nominated. 10 of the nominees in the Trump administration for lifetime appointments to the federal court had been found unanimously unqualified by the American Bar Association. But that didn't deter their nomination and in most cases their selection. Thankfully, with today's 5 nominees, the Biden administration has taken an important step toward orienting the courts back toward even-handedness, fair-mindedness, and competence. And the administration has done so with a group of nominees whose qualifications are beyond question. Now I have the honor and privilege of introducing 2 of them. I'll start with Candace Jackson-Akiwumi. nominated to an Illinois seat on the Seventh Circuit. Ms. Jackson-Akiwumi is the daughter of two judges. Her father, Judge Raymond Jackson, is a federal district court judge in Virginia. Her mother, Judge Gwendolyn Jones Jackson, previously served as a state court judge. Their daughter, Candace, received her undergraduate degree from Princeton, her law degree from Yale, where she served on the Yale Law Journal. She clerked for Judge David Coor on the U.S. District Court for the Northern District of Illinois, who incidentally heads my panel to approve nominees for the federal bench in Illinois, and Judge Roger Gregory on the Fourth Circuit Court of Appeals. She then practiced at the law firm Skadden Arps in Chicago and then did something which is highly unusual. She decided to leave the private practice to join the Federal Public Defender's Office in the Northern District of Illinois, working in that office for 10 years, leaving just last fall when she came to D.C. with her husband, Eric, pursuing a job opportunity. For the last several months, she's practiced at the D.C. office of the law firm Zuckerman Spader. However, upon confirmation, she will return to Chicago. Good for us. And I want to thank her husband, Eric, for adjusting his own career for the sake of his wife's. It is a sad reality that 4 years of President Trump and a Republican Senate did not expand diversity on our federal courts. This includes both demographic diversity and life experience. Over 4 years, President Trump appointed 54 judges to the circuit courts. 54. None of them, not one of them, was black. Currently, the Seventh Circuit has no judges of color. In fact, only one judge of color has ever served on the Seventh Circuit, my friend and the retired federal judge Ann Claire Williams, who was appointed by President Clinton with my strong support. In 2016, President Obama nominated a highly qualified black attorney named Myra Selby to an Indiana seat on the Seventh Circuit. Republican senators blocked her nomination for nearly an entire year. The NAACP has made it clear that this lack of diversity means something important to the federal bench. In a November 2020 letter, NAACP President Derek Johnson wrote, and I quote, "The absence of diversity undermines the integrity and legitimacy of the federal judiciary. Judges from different racial, ethnic, and other backgrounds enrich judicial decision-making and promote trust and confidence by communities impacted by their rulings." Thankfully, we have Ms. Jackson-Akiwumi before us today, highly qualified with a unique perspective, and only a tiny fraction have spent on the federal bench now, have spent the majority of their careers as public defenders or in legal aid. In fact, out of 179 current federal circuit court judgeships, there appear to be only 2 judges who spent a significant part of their legal career as federal public defenders, one of them from the state of Iowa, the 8th Circuit Judge Jane Kelly, and the 3rd Circuit's Judge Louis Restrepo of Pennsylvania. In contrast, there are many former federal prosecutors on the federal bench. Many are extraordinary jurists, but they do not share the same life experience as these nominees. As a federal defender, Ms. Jackson-Akiwumi represented over 400 indigent federal defendants at all stages of the criminal justice process. She has tried 8 trials to verdict and argued 6 appeals before the circuit court. She's litigated hundreds of contested hearings, including sentencing hearing. Ms. Jackson-Akiwumi knows the criminal justice system inside and out. She's exactly the type of nominee we should hope to see more of. I look forward to hearing more about her experience today. I also have the honor of introducing Judge Ketanji Brown Jackson, nominated to the D.C. Circuit. Judge Jackson was born right here in Washington, D.C., where her parents, who were natives of Miami, were at the time working as public school teachers. When she was 3 years old, Judge Jackson and her parents went back to Miami so her dad could go attend law school at the University of Miami. He later served as a principal attorney for the Dade County School Board, while Judge Jackson's mother served for 14 years as the principal of a leading magnet school in the Miami area. Judge Jackson herself attended Harvard and Harvard Law. She then went on to a series of clerkships at the District Court, on the First Circuit, and finally, Supreme Court clerkship for Justice Stephen Breyer. The breadth of her legal career is impressive, from her work in private practice at the law firm Morrison & Forster, to her service as an attorney on the U.S. Sentencing Commission, to her time as a federal public defender. Judge Jackson is well known to us on this committee in light of her prior nominations to the Sentencing Commission and the U.S. District Court for the District of Columbia. And I might note, she won unanimous support for both of these roles from this committee and from the Senate as a whole. There are two aspects of Judge Jackson's record I'd like to highlight. First is her tenure on the Sentencing Commission. The issue of criminal sentencing is one that is deeply important to me, and I'm sure to my colleague, Senator Grassley. As a Sentencing Commission member and as a federal judge who has handed down sentences, Judge Jackson has faced the often difficult questions inherent in that responsibility. She will bring that experience to bear on the D.C. Circuit. The second is more broadly her record on the federal bench. Judge Jackson has shown time and again in her decisions that she is guided not by ideology or a preferred outcome, but by a steadfast belief in approaching every case with fairness and impartiality. We see that reflected not only in her even-handed record, but in the comments of those who have served with her. She's won praise across the ideological spectrum, including from D.C. Circuit Judge Thomas Griffith, a George W. Bush appointee, who wrote to the committee in support of her nomination. Judge Griffith wrote, and I quote, "Although she and I have sometimes differed on the best outcome of a case, I have always respected her careful approach and agreeable manner, two indispensable traits for success in a collegial body." In these partisan times, Judge Griffith's words ring even more important. I look forward to hearing from Judge Jackson today and from all five of today's nominees. And with that, I turn it over to my friend and fellow colleague, the ranking member, Chuck Grassley.
Yeah. For the first three paragraphs of my remarks, I'd ask the Democrats to pay attention. It may sound facetious, but I want to make a point. Today, we're hearing from 5 nominees to be considered for judgeships, including 2 circuit nominees. Because this is the committee's first hearing on judicial nominees of this Congress, I'll be very attentively listening to my Democratic friends to see if I catch any apologies from them to Justice Amy Coney Barrett. You see, last fall, we heard from them time and time again for weeks that Judge Barrett was being put on the Supreme Court for 2 reasons. One, to steal the election from Donald Trump and to get rid of Obamacare. Well, I just checked Joe Biden is president of the United States, and Obamacare is still on the books. If my friends don't want to apologize to Justice Barrett publicly, she's right next door, and I'll bet she'd be happy to accept any apologies in person. Turning to today's nominees, Judge Jackson has been nominated to the D.C. Circuit Court, often called the second highest court in the land. Judge Jackson was appointed by President Obama to serve D.C. District Court 2013 and has been involved in over 500 cases as a judge since then. As someone who has been very interested and invested in criminal justice reform, as Senator Durbin has been, I appreciate Judge Jackson's work on the Sentencing Commission, where she also served. We'll also hear from Ms. Jackson-Akiwumi today, nominated for the 7th Circuit. She's a nominee who served as a federal public defender for 10 years in Chicago area before moving to D.C. and has represented over 400 criminal defendants, many of whom were charged with crimes involving illegal firearms. I'll be interested in hearing her views on the so-called gun pandemic and how violent criminals play into that. From my review of her record, it certainly seems that Ms. Jackson-Akiwumi has been a zealous advocate for her clients, and criminal defendants are deserving of competent representation in our justice system. But I'll be asking her today about some of the specific positions she's advocated for. I'm sure Democrats will complain that we shouldn't hold a nominee responsible for her clients, and perhaps that once was true. The fact is that previous nominees like Kyle Duncan, Howard Nielsen, Rosie Alston, Britt Grant, Mike Park, and countless others were opposed by Democrats because of the clients that they represented. At the same time, there's a growing hostility to fair representation on the left, with student radicals saying quote unquote, not everyone deserves representation, and liberal activists seeking to penalize law firms representing clients with wrong positions, so-called wrong positions on social or political issues. As a wise man said recently, it can't be one set of rules for Republicans and another for Democrats. So I plan to look at candidates' records, including their legal advocacy on behalf of clients. The fact is that the far-left group Demand Justice, which seems to be in charge of the judicial selections in this administration, says you can tell what kind of judge someone will be by their clients. They strongly support Judge Jackson and Ms. Jackson-Akiwumi because their time as federal defenders will apparently cause them to pursue social justice rather than follow the law. And of course, I hope not, and it's not an accusatory statement, but it does take off on some very fair accusations against nominees of one party versus the nominees of another party. This hearing is our first look at President Biden's judicial nominees. I'm hopeful that these nominees will engage with all senators and thoughtfully respond to our questions. Congratulations to all of you for your nomination.
Thank you, Senator Grassley. And a number of senators would like to formally introduce one or more of our nominees. And I have a list of those who are available. And the first is physically present from the state of New Jersey, our colleague, Senator Cory Booker.
Mr. Chairman, this is indeed an honor for me to be able to introduce the two nominees, Julian Neals and Judge Zaheed Qureshi. They've both been nominated by President Biden to serve the United States District Court judges for the District of New Jersey, and we are in a very severe judicial emergency right now. Both are highly qualified, experienced people who share an understanding of the impact that our courts will have on the people of our state and across this nation. The first individual I choose to introduce, we've done this again before. Judge Niels is someone that was nominated by the Obama administration and in 2015 to serve as a federal district judge, but unfortunately the Senate failed to bring his nomination up for a vote. Despite the delay on Niels' confirmation, I would like to again just speak to who he is. Judge Niels and I have worked together for a very long time. We have history. He's someone that I've had the honor of working with, and of all the people I've worked with in my career, and I've worked with extraordinary individuals, both here in the United States Senate and through my career in Newark, Judge Niels is unequivocally amongst the best people I've ever had the honor to work alongside. For 2 years, he serves as chief judge of the Newark Municipal Court, which is the largest court in the state, municipal court in the state of New Jersey. He personally presided over 6,000 cases, but he ushered in a spate of reforms, helping to create the state's first Veterans Court, the state's first youth court, and other innovations that helped Newark, New Jersey become a national model for court innovation. He then joined my mayoral administration. He served, again, at the head of the busiest corporation counsel's office in our state, the Newark Corporations Counsel's Office, and then he served as business administrator for the city of Newark. And he served at a time that we were in crisis. The city was going through the Great Recession, along with the rest of the planet Earth. I don't think there is any person here that was a former governor, a former county executive, or a former mayor who had to do what Julian and I had to do, which was to govern down our city size 25%, to cut our city's budget and to cut our personnel. Days and months and years of painful work of getting our budgets to fit with the massive shortfalls in revenue that we had. He is a brilliant, skilled administrator who has a balance and an equipoise to keep his head about him when all else are losing theirs. He currently serves as the counsel to New Jersey's biggest county, Bergen County, the county of my birth and where I was raised. If you talk to people in Bergen County, they talk about him almost as if he is a holy, sanctified figure. They say he has more cool than Obama. They say he is one person that truly, when they walk into a room, everyone listens. Bergen County, New Jersey is a political place with a lot of fiefdoms and a lot of different power bases. But Julian seems to sail above it all with great dignity and a great sense of expertise that trumps all politics. I am so honored to know this human being. And when I imagine what a federal judge should be, I imagine someone with the qualities, the gifts, the kindness, the decency, and the love for others that Julian Niels possesses. It is an honor for me, not only to introduce him, but to have recommended him to the President of the United States. And it is so great to see my old friend here today. The second person I'd like to introduce is Judge Zaheed Qureshi. Judge Qureshi is someone who has had an extraordinary life of commitment to country. He is a dedicated public servant who has served this nation in many roles. You said it, Mr. Chairman. He was in the military, in the JAG Corps, at the Department of Homeland Security, and most recently worked as an assistant United States attorney in the office of the U.S. Attorney for New Jersey. He currently is a federal magistrate judge in New Jersey. This is someone who believes in this nation and her ideals and is dedicated to serving them. He has honors in just about everything that he has done, including his military service. Judge Qureshi is a well-respected person who is also seen as a standout in our state. He is one of the best that New Jersey has. His legal skills and experience will serve the people of New Jersey in our judicial crisis as a U.S. District Court judge. It has been said also that if he is confirmed, Judge Qureshi will be a history maker as the first Muslim American Article III judge in all of our country's past. And because of his example, because of his leadership, because of his character, he will most certainly not be the last. Both of these nominees are dedicated to the rule of law, to justice and fairness. Both of these nominees will help to restore integrity and independence and public faith in our courts. And both of these nominees are exceptionally, extraordinarily, unequivocally qualified. I thank President Biden for recognizing and nominating Judge Niels and Judge Qureshi to serve as the United States District Court judges for the District of New Jersey, and I strongly urge my fellow committee members to support their nominations. Thank you.
Thanks, Senator Booker. Senator Bennett, I believe by remote. Are you there, Senator Bennett?
I'm here. Can you hear me, Mr. Chairman?
I hope we can get your volume up just a bit, but we can't hear you. Please proceed.
Okay, can you hear me now?
Yes.
Okay, thank you. Well, thank you very much, Chairman Durbin and Ranking Member Grassley, for inviting me to share a few words about Regina Rodriguez, President Biden's nominee for the U.S. District Court for the District of Colorado. Gina comes to this committee with broad support in my state. We've received a flood of letters on her behalf. All of them testify to her character, hard work, and commitment to justice and the rule of law. She learned all of it from her family, who join us today. Her mom's family knew injustice firsthand. As the chairman mentioned, during the Second World War, they were relocated from California to the Heart Mountain internment site in Wyoming, joining over 10,000 people whose loyalty to America was questioned for no reason but their Japanese ancestry. Her father, Peter, was a Mexican American who went from living in a railroad boxcar on the south side of Chicago to earning a nomination for the NFL Hall of Fame. Her mother, Linda, became a teacher and administrator in the Denver Public Schools, my old district, when I served as superintendent. Education and hard work transformed her parents' lives, and Regina has always sought to live up to their example. She graduated, the ranking member might be interested to know, with honors from the University of Iowa, then returned home to earn a JD from the University of Colorado Law School. After starting at a private firm in Denver, Gina joined the U.S. Attorney's Office. The Department of Justice recognized her talent, and she went to work for the Attorney General on alternative dispute resolution, a new approach at the time meant to avoid lengthy trials through arbitration and mediation. Gina helped to mainstream this approach for all U.S. attorneys, saving the government countless hours and taxpayer dollars. Regina's leadership in Washington earned her a promotion back in Denver, where she rose to become chief of the civil division in the U.S. Attorney's Office. Today, she's one of the most respected trial lawyers in Colorado and has received award after award for her work. Her commitment to the community has been just as impressive. She's a founding board member of Colorado Youth at Risk, a nonprofit that helps kids stay on the right track. She served as one of Colorado's higher education commissioners and still serves on the board of Denver's highest performing charter school. Somehow, she still finds time to mentor lawyers from underrepresented communities. I could go on, but the evidence is overwhelming. Regina Rodriguez is an exceptionally qualified nominee with a distinguished career and commitment to service. She's blazed trails in Colorado law through the sheer force of her intellect, hard work, and character. She has my full and enthusiastic support, and I urge the committee to approve her nomination.
Thank you, Senator Bennett. I believe Senator Duckworth is available remote. Senator, can you hear us?
I sure can.
Please proceed.
Thank you, Mr. Chairman and Ranking Member Grassley. Thank you both. It's my honor to appear before this committee to both introduce and to offer my strong support to Ms. Candace Jackson-Akiwumi, President Biden's nominee to be the next United States Circuit Judge of the 7th Circuit. Ms. Jackson-Akiwumi exemplifies President Biden's fulfillment of his promise to nominate highly qualified individuals to the federal judiciary who reflect the incredibly diversity of our great nation. As one would expect, Ms. Jackson-Akiwumi possesses an impressive academic background, graduating with honors from Princeton University and then earning her JD from Yale Law School, where she served as a senior editor on the Yale Law Journal and was an NAACP Legal Defense Fund Earl Warren Legal Scholar. After graduation, she quickly gained experience serving in the federal judiciary, first clerking for the Northern District of Illinois, Judge David Corr, and then for 4th Circuit Judge Roger Gregory. I was especially struck by Ms. Jackson-Akiwumi's commitment to public service. She has dedicated the majority of her legal career to public service and spent a decade in the city of Chicago serving as a staff attorney in the Federal Defender Program. As that public defender, Ms. Jackson-Akiwumi gained immense litigation experience while advocating for those who are often the most vulnerable and underserved in our communities. She represented over 400 defendants, tried 7 jury trials, and argued 5 appeals before the 7th Circuit. Ms. Jackson-Akiwumi is currently a partner at the law firm of Zuckerman Spader, where she is a member of the firm's business litigation, investigation, and white-collar defense groups. However, even in the private sector, Ms. Jackson-Akiwumi demonstrated a strong commitment to public service, spending a significant portion of her time working on pro bono matters involving adoption, civil rights, criminal law, and immigration. For example, she won lawful permanent residency and protection under the Violence Against Women Act for a mother with her 2 children, advocated for better conditions for incarcerated clients, and represented an employment discrimination plaintiff in a successful EEOC mediation. Beyond Ms. Jackson-Akiwumi's accomplishments, it is important to recognize the groundbreaking nature of her nomination and the urgency of moving swiftly to confirm her. If seated on the bench, she would be only the 2nd Black woman in history to serve on the 7th Circuit and the only person of color serving on that court today. Equally important, Ms. Jackson-Akiwumi would strengthen the 7th Circuit by bringing a broad diversity of experience with her, particularly her time serving as a public defender. Mr. Chairman, thank you again for allowing me to introduce Ms. Jackson-Akiwumi, and I strongly urge the committee to act favorably on her nomination.
Thank you, Senator Duckworth. Next up is our friend and colleague from the state of New Jersey, Senator Menendez. Are you with us, Senator? We'll come back to Senator Menendez in a minute. And currently, I believe Senator Hickenlooper of Colorado is waiting. Senator, can you hear us?
Yes, thank you, Chairman Durbin.
Please proceed.
And Ranking Member Grove. Can you hear me?
Please proceed.
Yes. Yes, thank you, Chairman Durbin and Ranking Member Grassley for letting me share a few words about Regina Rodriguez. President Biden's nominee for the U.S. District Court for the District of Colorado. And I want to add a little bit to what Michael Bennett said so elegantly. I mean, Regina Rodriguez comes to this committee with broad, well-earned support in our state, 30 years of legal experience and accomplishment, and she really has dedicated her career to the people of Colorado and fighting for historically disadvantaged communities. It's not surprising that she got the enthusiastic support of the Colorado Lawyers Committee, the Colorado Sam Carey Bar Association. These two organizations consist of attorneys dedicated to providing legal services to children, to the poor, to using knowledge of the law to improve our society and our legal system. Former United States attorneys appointed by presidents from both political parties note that Regina's experience, knowledge, demeanor, and work ethic make her really an ideal candidate. Throughout her career, she has managed complex matters that required the coordination of hundreds, if not thousands, of cases and trials in multiple jurisdictions. Given her extensive experience representing both plaintiffs and defendants, Rodriguez understands the importance of applying the law even-handedly, based always on the facts. As the Latina First Foundation put it, there is no person better qualified to effectively serve on the U.S. District Court than Regina Rodriguez. I wholeheartedly agree. Regina has my full support, and I hope this committee will confirm her nomination and that the Senate will act swiftly to confirm her. Thank you, Chairman Durbin, Ranking Member Grassley, and all the members on the committee for your consideration of this outstanding nominee.
Thanks, Senator Hickenlooper. And now the question is whether Senator Menendez is available.
I am available, Mr. Chairman.
Good. Thanks. Please proceed, Bob.
Thank you, Mr. Chairman, and to Ranking Member Grassley and distinguished members of the committee. It's my great privilege to join my colleague from New Jersey, a distinguished member of the Judiciary Committee, in recommending two highly qualified nominees to the United States District Court for the District of New Jersey, Julian Niels and Zahid Quraishi. These nominees represent the best of New Jersey. Both reflect our state's proud and uniquely rich diversity, and both demonstrate a steadfast commitment to equal justice under the law. Mr. Niels has served as the county counsel for Bergen County since 2015. Prior to taking on that role, he has served the people of Newark in an array of capacities. From 2010 to 2014, he was the business administrator for the city of Newark, the highest appointed administrator in New Jersey's largest city. He also led the city's Department of Law and served as chief judge of the Newark Municipal Court. He commands enormous respect in our legal community, from serving on the Supreme Court of New Jersey's Committee on Character and Fitness to serving as chairman for Volunteer Lawyers for Justice. He personifies the meaning of public service. Mr. Neal's tremendous breadth of knowledge and experience, even temperament, and exacting judgment make him a superb candidate to serve on the federal bench. Also honored to join in introducing Zaheed Qureshi, who today serves as a U.S. Magistrate Judge for the U.S. District Court for the District of New Jersey. Prior to his appointment, he was a partner at the firm of Riker Danzig. There he chaired the White Collar Criminal Defense and Investigations Group and served as the firm's first Chief Diversity Officer. Judge Qureshi also served as an Assistant United States Attorney for more than 5 years in Newark. Previously, he served our country as a military prosecutor with the U.S. Army Judge Advocate General Corps, where he achieved the rank of captain. Beyond his impeccable credentials, if confirmed, Judge Qureshi would also make history as the first Muslim American federal judge and the first Asian American to serve on the federal bench in New Jersey. Judge Qureshi has demonstrated both integrity and intellect throughout his distinguished career in public service, and I believe he will bring to this position the wisdom, experience, and demeanor that the District Court of New Jersey deserves. Finally, Mr. Chairman, members of the committee, New Jersey's District Court currently faces 6 vacancies, all of which have been declared judicial emergencies by the Judicial Conference of the United States. So I strongly urge the committee's unanimous support and hope that we can have a speedy confirmation process on these qualified nominees. Thank you, Mr. Chairman, for bringing up these nominees as quickly as you have, and we look forward to working with you in the days ahead.
Thank you, Senator Menendez. Would our first 2 nominees please stand to be sworn? equipment timeout. Ready? Do you swear or affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect both witnesses have answered in the affirmative. And we will start with Judge Jackson. You may make an opening statement at this time.
Good morning, Mr. Chairman. Thank you very much. It is an honor to appear before you all this morning, and I would like to start by expressing my sincerest gratitude to you, Mr. Chairman, for scheduling this hearing and for introducing me. And I would also like to extend my thanks to Ranking Member Grassley and to all of the members of the committee for participating in this hearing today. I have had the great privilege of having been invited to come before this committee twice before for confirmation, so I know that I've already taken up a great deal of your collective time, and I am both humbled and very grateful to be here once again. I'm also truly thankful to President Biden for giving me the honor of this nomination to the Circuit Court. Mr. Chairman, I don't have opening remarks, but I would like to introduce you to my family members, some of whom have traveled great distances to be here today. I'm going to refrain from giving individual tributes, but I want each of them to know that their love and encouragement has meant so much to me throughout the years, and there's no question that I would not be who I am or where I am today without their support. I would like to start with my parents, Johnny and Ellery Brown, who left their permanent home in Miami, Florida last week for the first time since the start of the pandemic and traveled here by way of West Virginia, where they partially reside. My parents-in-law, Gardner and Pamela Jackson, are lifelong Boston and Cape Cod residents, and they too made the effort to travel here via I-95 to be here with me today. Also here are my terrific brother-in-law and sister-in-law, William and Dana Jackson, who live in Maryland. And if William looks familiar, it is because his identical twin brother is my husband, Dr. Patrick Jackson, who is also here. He did not have to travel very far. He's actually been with me all along during this incredible journey by my side for 25 years, come this October. Finally, also here today is the younger of our two daughters, Layla, who is a junior in high school. She is in the most demanding season of this extraordinarily challenging academic year, so it is a special treat for me that she is with us today. As a side note, our older daughter, Talia, would have made the effort, but she's a freshman in college, and after spending 3/4 of this academic year taking classes from her bedroom, she finally got the chance to live on campus just 3 weeks ago, and I didn't have the heart to make her come back again. Mr. Chairman, there are so many other members of my family who could not be here with us at this time. They are in Wisconsin and Florida and Utah and Colorado and Massachusetts, and some are dearly departed. I am truly grateful for all of them and for all of the wonderful friends around the country who are watching these proceedings and cheering me on through this process. So with that, Mr. Chairman, let me once again reiterate my thanks to you for inviting me here this morning. I am enormously grateful, and I look forward to answering the members' questions.
Thank you, Judge Jackson. And Ms. Jackson-Akumi, please proceed with your opening remarks.
Good morning. I am deeply grateful to the senators from my adopted home state of Illinois, Senators Durbin and Duckworth, for their warm introductions of me. I'm grateful to Chairman Durbin and Ranking Member Grassley for convening the hearing today, and all of the members here for considering my nomination. I also am grateful to the President for the honor of this nomination. My immediate family is here today supporting me. I struggled for words to succinctly capture how truly wonderful they are and what a gift they are to me. My parents have traveled from my hometown of Norfolk, Virginia, to be here. They are, just over my right shoulder, my father, the Honorable Raymond A. Jackson, United States District Court Judge for the Eastern District of Virginia. Seated next to him, my mother, the Honorable Gwendolyn Jones Jackson, a retired judge for the Commonwealth of Virginia. My siblings are here today as well. My sister is the Reverend Arlette Estelle Jackson. She did not travel far. She's a longtime resident of the District of Columbia. My brother is here, Raymond Daniel Jackson, attorney at law. He's traveled from Tampa, Florida, to support me today. And last but not least, my husband, Eric Akumi. He remains the best friend that I have ever had, in addition to the many other amazing roles he plays in our partnership. My husband and I have not invited today our very active 15-month-old daughter, Noelle. We will all be much more productive today without her here. Also missing is Noelle's big brother, my 14-year-old stepson, Isaiah, who lives in Tampa, Florida. He will be watching this hearing later today as an excellent civics lesson in the advise and consent role of the United States Senate. There are obviously many other family members and loved ones and friends who could not be here today because of the COVID restrictions here in the building, but I'm deeply grateful to them all. My family is the best part of me, and I would not be here today without their love and support. Thank you again.
Thank you very much. Before I turn to questions, I want to lay out a few of the standards we're going to follow. At the request of Senator Grassley, he has asked that for these two circuit court nominees that we have 7 minutes to ask questions. I asked Senator Grassley before this hearing how he enforced the time when you announced these things, and he came up with the Grassley rule. I'm sure I won't state it in its entirety, but basically said, if you're in the midst of a question as your time runs out, finish the question, but try to keep it short and keep the answer short. Is that about right? Okay. My ruling has been blessed by Senator Grassley, so we have a bipartisan start here. The second panel on district court nominees will go back to the five-minute standard. So let me start my questioning under the 7-minute rule. You both have an extraordinary background in having served in the Federal Public Defender's Office, representing indigents and people who often struggle in our system of justice. I think we know that we're engaged in a national conversation now about justice, long overdue. And it's raised questions about law enforcement, questions about sentencing, questions about incarceration. It really calls to question the agenda of this committee, the Senate Judiciary Committee, on the criminal justice side. You've got a special perspective that you bring to this that many nominees don't, in light of what you have done with your life. I don't want you to address any case or any specific situation, but I'd like for your observations, because you've spent such a big part of your lives. It goes back to what Langston Hughes once said, spend such a big part of your life. For those who would say, life for me ain't been no crystal stair. Folks who, black, brown, poor defendants who seeking representation in a system that seems to them just overwhelming and fundamentally unfair in some cases. What would be your general thoughts, without any specific case in mind, about justice in America today and how you've seen it and how it's changed in your time? Judge Jackson?
Thank you, Senator. I had the privilege of serving as a federal public defender, assistant federal public defender in Washington, D.C. I think it was some 16 years ago. And as part of that experience, I, as you say, represented people. I represented them in the appellate division of my office. So all of my clients were convicted. And I think that the insights that one gains from that kind of professional experience really can be very helpful in future endeavors, especially if you go into the judicial service, as I have. And I can give you a concrete example. When I worked with my clients as a defender, my job was to talk with them and to try to get their help to identify errors, things that had gone wrong in their trial proceedings so that I could raise them on appeal. And one of the things that I noticed that I was really struck by was how little they could help me with that project. Most of my clients didn't really understand what had happened to them. They'd just been through the most consequential proceeding in their lives, and no one really explained to them what they were supposed to expect, so they didn't know where things might have gone wrong. And I remember that experience from all those years ago when I became a trial judge. One of the things that I do now is I take extra care to communicate with the defendants who come before me in the courtroom. I speak to them directly and not just to their lawyers. I use their names. I explain every stage of the proceeding because I want them to know what's going on. And when I have to sentence someone, and I've sentenced more than 100 people to date, I always tell them, I explain to them, this is why your behavior was so harmful to society that Congress thought that it had to be made a crime. And I say, this is why I, as the judge, believe that you have to serve these consequences for your decision to engage in criminal behavior. And I think that's really important for our entire justice system, because it's only if people understand what they've done, why it's wrong, and what will happen to them if they do it again, that they can really start to rehabilitate. So there is a direct line from my defender service to what I do on the bench, and I think it's beneficial.
Thank you. Ms. Jackson-Akiwumi, I noted in my introduction that you made the extraordinary career move from private practice to the Federal Defenders Program for 10 years, I believe, that you served there. So I'd like you to consider the same question I just asked Judge Jackson, and in the process, perhaps you'd comment on demeanor and temperament of judges.
Certainly, Senator. Thank you for the question. I can think of two observations from my time serving as a federal public defender that I think will bode well for me in serving the public as a judge, if confirmed. First is the importance of listening and the importance of being heard. It's actually something I learned well before I went to law school from my mother when she served as a judge. She often talked about the importance of letting people make sure they've been heard by the court, because it's easier for people to accept even adverse rulings by the court when they at least know they've been heard. That's built into our system of due process, which involves an opportunity to be heard. A cousin to that is listening. I gained an extraordinary amount of experience listening as a federal public defender, listening to the views of opposing counsel, prosecutors, about their views of the case, to find out where we might negotiate, where we might find common ground, listening to the stories of my clients to understand why and how they came to be standing before the court and what their fears and questions were, and listening very carefully to the questions that piercing trial judges and appellate judges were asking me about the case. And so being a federal public defender sharpened my listening skills, and I know that even though the job of advocate and judge are completely different, one skill that should translate well for me is that of listening, because circuit judges, above all, must listen to the parties before they even attempt to reach a reasoned decision. The other observation from my time in the criminal justice system as an advocate is the importance of setting aside personal convictions, personal opinions. At the Federal Defender Program, we represented whoever walked in the door, charged with whatever crime, so long as they needed an attorney, so long as they were poor and working class and could not afford an attorney. That's what the Constitution and the case law dictated. With each and every case, I had to put aside any personal opinions I had about my client and any personal opinions I had about what they were accused of or the behavior, and represent them zealously in the courts. And again, even though the role of advocate and judge are completely different, that is one similarity. Like a federal public defender, a judge has to set aside their personal opinions and their personal convictions in decision-making. Thank you.
Thank you. Senator Grassley?
Yeah. I'm going to start with Jackson-Akiwumi. During the most recent Seventh Circuit hearing, we heard about the supposed link between Indiana gun shows and street violence in Chicago. For 4 years, you represented a man who, during 1 year, had bought 9 firearms in Indiana gun stores and proceeded to sell them without a license to people in Chicago, including at least one felon. He was investigated when the police in Chicago recovered 7 firearms that he had bought in Indiana. You said in the pretrial motion that, quote, "This case is not about gun violence or gangs in Chicago," end of quote. Do you stand by the view that a case about illegal firearms trafficked from Indiana to Chicago is not about guns, violence, or gangs in Chicago?
Senator, I lived in Chicago for many, many years, my formative years as an attorney and just as a private citizen, so I am all too aware of the crisis regarding guns that Chicago faces and so many other communities face. It affects me personally as a citizen. I stand by my commitment and the oath that I took as an attorney, which is to represent zealously everyone who requires representation in our federal courts. And that is without regard to the crimes they are charged with. That's how our system works best. If you look at the Sixth Amendment and how the Supreme Court has interpreted the Sixth Amendment in Gideon v. Wainwright, it talks about the right to counsel, and there's no limitation on that based on what someone is charged with.
I think I'll accept that answer. Going on the same case, do you agree that vigorously prosecuting unlicensed firearm traffickers is the best way to stop pipeline of illegal guns into the city of Chicago? That should be an easy one to answer.
Well, Senator, thank you for the question. I think there are a number of tools in the toolbook for combating an issue like guns and gun violence. Prosecution is one tool. I also know that this body and other legislative bodies at every level, state, federal, and local, have to consider these issues and have been working on these issues vigorously. So there are just a number of tools out there.
Thank you. Last question on that case. Well, no, it's not really on that case. Just give me a very rough idea of how many firearm traffickers you've defended in court, just a rough number.
Senator, I appreciate the question. It'd actually be hard to say. I've always described my career over a decade like this. About a third of my cases involved a panoply of fraud. There are so many frauds in the United States Code book, it would blow your mind. A third of my cases involved drugs and firearms, whether it was possession of firearms, trafficking of firearms, and then about a third of my cases involved a big mix of everything else, from bank robbery to immigration offenses, sex offenses. So it would be difficult to give you an exact number.
I accept that
right
answer.
now.
Second point with you. In your sentencing memoranda, you repeatedly highlighted the sentencing differences that exist between black defendants and white defendants charged with the same crime. In fact, you've gone so far as to argue that your black clients should not receive a sentence higher than any applicable mandatory minimums, quote, to avoid further entrenching proving racial disparities, end of quote. As a sitting senator, I agree with your policy points about racial disparities in the laws we write, but I have concern about the courts engaging in those policy arguments. When you made these arguments in court, did you expect district judges to let broad social policy concerns govern how they applied the law in the case before them? And maybe I can give you a short answer. You would say they should apply the law, not the policy, right?
Well, Senator, yes, because that's actually the law that Congress passed. Congress passed the sentencing statute, 18 U.S.C. 3553A, and one of those factors Congress has said that judges should consider is disparities, any disparities that might result from the sentence the judge imposed. So in those cases, like the one that you provided an example of, I was asking the court to apply that statutory sentencing factor.
Okay. Another question, if district judges should let policies concern governing how they apply the law, would it be right for them to give white defendants longer sentences than the facts require in order to correct racial disparities?
Senator, every sentencing judge that I've ever appeared before has been guided by the same statute I've referred you to, 3553A, which sets forth at least 7 sentencing factors, including disparities. So everyone in the system, both the judge and the attorneys, are operating within that framework that Congress provided. And if confirmed, that is the exact framework that I would be looking to in order to review any sentencing decisions by judges.
I accept that.
Okay.
As an appellate judge, would you have the ability to take social facts such as racial disparities into consideration when reviewing a sentence?
Senator, what guides for circuit judges and what would guide for me if confirmed is the law and applying the law to the facts of any given case. That is purely what guides.
I think I'm going to take my last I'm going to send a question to you for answer in writing so I can ask Judge Jackson only one question. You've worked on sentencing reform, and as someone who has worked hard on the First Step Act and other issues of criminal justice reform, I really appreciate your work on the sentencing reform. Now, when it comes to more sentencing reform, people like you and Judge Bill Pryor both agree sentencing needs to be reformed. Can you explain how your views differ from Judge Pryor's, or specifically, why do you trust judges with more discretion when it comes to sentencing than Pryor does?
Thank you for that question, Senator. And first, let me just say, as a former member of the Sentencing Commission, thank you for your work. I know that the chairman, that Senator Lee, and others on this committee were very, very active in making changes to the sentencing system, partly because the commission did research and pointed out to you some of the disparities in our laws, and Congress has made changes that have been very beneficial to the system. I did have the privilege of serving with Judge Pryor. We were on the commission together, and he and I both did talk quite a bit about, in our public statements and in the meetings, about the need for reform and how do we change the system after the Supreme Court's decision making the guidelines advisory and not binding anymore on judges. I would say my primary answer is because in my experience, most judges really don't like to be outliers when they're sentencing. Most judges really do want to do something that is consistent, not only with the law, but also with what similarly situated other defendants are getting in their district. So in my view, instead of more mandatory minimums or prescriptions that actually bind judicial discretion, if we could just give judges more information, that turning to a repository of information like the Sentencing Commission that captures every sentence that federal judges give, and then giving judges access to that information is a way of ensuring that judges are handing out fair sentences that are similarly situated to other defendants. I think Judge Pryor he said that we need to do a little bit more to constrain judicial discretion, but my hope and faith is that judges will constrain themselves to an extent when they get the information that they need.
Senator Feinstein?
Thanks very much, Mr. Chairman. According to the Center for American Progress, only 1% of sitting circuit judges have spent the majority of their career as public defenders or within a legal aid setting. In light of this fact, I just want you to know that I'm very pleased that we're considering 2 nominees today with extensive service as public defenders. So I want to ask you this question. There are some critics who claim wrongly in my book that a public defender can't function as an impartial judge. How do you respond to this question? The judge may go first.
Thank you, Senator. Well, I've been a judge for 8 years, and as I mentioned at the outset, I think that actually having defender experience can help not only the judge, him or herself, in considering the facts and circumstances in the case, but also help the system overall in terms of their interactions with defendants and the way in which they proceed in the courtroom. I would think that there would be no difference between defender experience and prosecutorial experience from the standpoint of whether or not someone can do what the law requires. And many, many prosecutors have been appointed as judges. When you become a judge, you take an oath to look only at the law in deciding your cases, that you set aside your personal views about the circumstances, the defendants, or anything else, and you apply the law. So I guess I would just say that that I wouldn't see any distinction between people with prosecutorial backgrounds and defense backgrounds in their ability to stay true to their oaths.
Thank you. Judge Jackson, also, I was impressed to learn that according to the Alliance for Justice, you have a reversal rate of less than 2% of your more than 550 decisions since assuming the role of U.S. District Judge for the District of Columbia. To what do you credit that 98% affirmative rate on appeal?
Oh, thank you, Senator. I think it might be my methodology in the way that I approach cases. And what I'll say about that is that when I get a case, if you look at my 550 cases, you'll see that there's a consistency in the way in which I'm analyzing the issues. I'm applying a particular method as the Supreme Court has directed, which is that I'm looking only at the arguments that the parties have made, at the facts in the record of the case, and at the law as I understand it. And I'm sticking very closely to those 3 inputs. And I'm also applying the same amount of analytical rigor to my analysis of those inputs. And as a result, I think I'm not making many errors, although the DC Circuit tells me that I do occasionally. But I'm doing that because I want to see every case through the same analytical lens. And it doesn't make a difference whether or not the argument is coming from a deaf inmate or the President of the United States. I'm not injecting my personal views. I'm looking at those 3 things. And I think by being very methodical, I've been able to produce opinions that the circuit can see my reasoning and they understand that I'm even-handedly applying the law in every case.
Thank you. I'd like to ask the other candidate here, since the Supreme Court held in U.S. v. Booker that federal sentencing guidelines are not binding on judges at sentencing, we've seen a gradual return to discrepancies in the way different judges at different courts sentence those before them. How do we ensure fairness and consistency in sentencing while maintaining judicial discretion consistent with the Supreme Court's ruling in Booker?
Senator Feinstein, thank you for what is really an incredibly difficult question that you've rightly recognized. That is, in fact, why the guidelines were invented, created to avoid disparities, and then that's why they were moved from mandatory to advisory to remove disparities and give judges more discretion. Sitting here today, what I know is that it would not be my role as a circuit judge, if confirmed, to opine on those issues and sort through those issues in the way that, for example, the Sentencing Commission would and this body would. But my role would be to review cases very carefully, review the record scrupulously, to see if sentencing judges at least adhered to the sentencing law and took into account fairly all of the factors that they were supposed to. If I may address your earlier question about public defenders being able to be fair and neutral judges, I'll note that in the Northern District of Illinois, this body has confirmed a few district court judges at the district court level with public defender experience. Those judges have been serving a long time, and they are all doing so diligently, fairly, neutrally, impartially. And I'll also note that my entire career, I've had to work within the framework of the rule of law. Every argument I ever made to a court was grounded in the Constitution or a statute. You don't get anywhere with our fine judges of the Northern District of Illinois and the Seventh Circuit if you make up arguments that don't have a basis in law. And I've even had to advise clients when the law is not on their side, when they had an argument that they hoped we might be able to make, and I did the research, or I knew immediately that there was no law to support that argument. That happened many times. So I am confident that I can serve, if confirmed, as a neutral, fair, impartial judge who works within the rule of law. I've had to do it my entire career.
Thank you very much. Thanks, Mr. Chairman.
Senator Cornyn, I'm sorry.
Thank you, Mr. Chairman. Let me say to both of the nominees, I very much appreciate the fact that both of you have had extensive trial court experience as practitioners and as a judge in the case of Ms. Jackson. I think that's a very important qualification for somebody who's going to sit in judgment on an appellate court, that they actually know how the trial courts operate and understand the appropriate standards of review on appeal. Both of you have a very impressive background. I agree with my colleagues that it's important to have, for the public, have confidence in the judiciary. And I think part of that confidence is knowing that people like them can serve on the bench, and that we applaud that diversity. I've noticed a difference in the way those issues have been treated in the past when my Democratic colleagues blocked, for example, Janice Rogers Brown, an African-American on the D.C. Circuit, Miguel Estrada. Thankfully, we've had some great judges in the Western District and Northern District of Texas, people like Ada Brown and Jason Pulliam in San Antonio, and then Asian American Circuit Court Judge Jim Ho, who was confirmed for the Fifth Circuit. But since our Democratic colleagues seem to be placing so much emphasis on race, and I just want to ask this question. None of us can choose our parents, and even if we could choose our parents, I suspect that most of us would choose the very parents we have. But what role does race play, Judge Jackson, in the kind of judge that you have been and the kind of judge you will be?
Thank you, Senator. I don't think that race plays a role in the kind of judge that I have been and that I would be in the way that you asked that question. As I mentioned to Senator Feinstein, I'm doing a certain thing when I get my cases. I'm looking at the arguments, the facts, and the law. I'm methodically and intentionally setting aside personal views, any other inappropriate considerations, and I would think that race would be the kind of thing that would be inappropriate to inject in my evaluation of a case. I would say that my different professional background than many of the Court of Appeals judges, including my district court background, which will be different if I'm confirmed than many of my colleagues, would bring value. It's sort of like the Oliver Wendell Holmes quote that the life of the law is not logic, it's experience. And so I've experienced life in perhaps a different way than some of my colleagues because of who I am. And that might be valuable. I hope it would be valuable if I was confirmed to the court, the circuit court.
Thank you very much. Ms. Jackson, the same question for you, please.
Thank you, Senator. I agree with Judge Jackson that I don't believe race will play a role in the type of judge that I would be if confirmed. I do believe that demographic diversity of all types, even beyond race, plays an important role in increasing public confidence in our courts and increases the public's ability to accept the legitimacy of court decisions. It's very akin to the way in which we guarantee a jury of one's peers, and the idea that you walk into the courtroom and 12 people from all kinds of different backgrounds might decide your case. I also think that demographic diversity of all types helps us achieve a role modeling result for young students, law students, young lawyers. It's important for anyone aspiring to public service to know that that path is open to all.
Well, thank you very much for that answer. For what it's worth, I agree with you. It's well said. Judge Jackson, I just have a few questions for you. You know, in this town, there's a lot of people expressing themselves on a variety of topics, and I know you're not responsible for what these third parties are saying, but I just want to ask you, first of all, are you familiar with an organization called Demand Justice?
Senator, I know of Demand Justice, yes.
And do you know that they are spending money to promote candidates, your nomination to this circuit court?
If you mean by advertising or placements in various publications, I'm aware of that.
Okay. And on their website, they say they advocate adding additional seats to the Supreme Court. Do you think Congress should add additional seats to the Supreme Court?
Senator, as a sitting judge, I am bound by the Supreme Court, and I don't think it's appropriate for me to comment on the structure or the size of the court any more than it would be for me to comment on the court's rulings. Regardless of the size, I would follow the precedents of the Supreme Court.
Demand Justice claims that the Supreme Court is broken. Do you think the Supreme Court is broken?
Senator, I've never said anything about the Supreme Court being broken, and again, you know, I'm not able to comment on the structure, the size, the functioning even of the Supreme Court.
And finally, Demand Justice says that the Supreme Court has been captured by partisan Republican interests on their website. Judge Jackson, Ms. Jackson, do you agree with that or disagree, or do you have no opinion? Judge
Well-
Jackson first.
Senator, I, again, am not able to make any comment about whether or not the Supreme Court is influenced in the way that demand justice apparently, as you say, believes that it is.
Ms.
So
Jackson.
I don't have a comment.
Thank you. Ms. Jackson?
Yes, Senator, I'm not aware of that quote by Demand Justice or anything they've said, quite frankly. But likewise, the Code of Conduct for United States judges does apply to nominees as well. And so, like Judge Jackson, it would not be appropriate for me to comment on any type of views about the Supreme Court. The Supreme Court's rulings would be binding on me as a circuit judge.
Thank you very much. Good luck to both of you.
Thanks,
Thank you.
Senator Corn and Senator Whitehouse.
Thanks and welcome to you both to the committee. I'm sorry we're so far apart and spread out here. That's the nature of the pandemic. Usually it's a setting in which we can see one another a little bit better. I wanted to ask you both questions about fact-finding at the appellate level. We had an interesting hearing in my courts subcommittee yesterday on this very question. It was my training in law school, my training when mentored by experienced appellate advocates, and my mentoring when I was trying to bring along other appellate advocates to stay the hell away from the facts. Because really the only two ways that an appellate court gets to look at facts is either to be asked to overturn a factual determination by the court below, which is heavily defended by the clearly erroneous standard, and therefore not usually a great avenue for appellate advocacy, or facts that are really not in dispute, facts of which judicial notice can be taken, that Christmas fell on a Wednesday in a particular year or whatever. What are your thoughts about the role of appellate courts engaging in fact-finding that is outside of the record that's presented to the court, either by Congress, as it put together the statute that is the subject of the challenge, or by the court below as it assembled the record to support its decision? What, as an appellate judge, do you get to do at that point regarding facts?
Well, thank you, Senator, for that question. Let me just say that my training was similar to yours in terms of the judges for whom I clerked at the appellate level and the way in which, at least, I was taught to think about the role of the appellate court in terms of the facts. I don't, as I sit here, know what the practice is in the District of Columbia, and I will say that we have a little bit of an unusual docket insofar as so many of our cases come through the administrative process, where even at the district court level, we're not looking at trials very much, and we're not developing a factual record very much. There is already an administrative record that travels with the case. So I think, I would
So
have
let's say whether it's a congressional record or whether it's an administrative agency record or whether it's a trial court record, those are three sources that a appellate court can draw from to determine what the facts are in the case and to support or overrule the finding of the district court. What happens when a court goes outside those records and starts finding facts on its own, sua sponte?
Yes, I frankly don't know. I would have to talk with my colleagues and look at the federal rules of appellate procedure and the practices, local rules of our court. I'm not sure the circumstance in which the appellate court would feel at liberty to do that sort of thing.
Okay.
Yes, Senator. Broadly speaking, Senator Whitehouse, federal courts are courts of limited power. And one duty of circuit court judges, and I remember this very clearly from my time clerking on the Fourth Circuit Court of Appeals, is to be quite restrained. Federal judges are supposed to be restrained and decide only the issues that appear before them and no other issues. It extends in the way you described to fact-finding. So it would be, from my experience, both clerking and then also litigating before the Seventh Circuit Court of Appeals, quite rare for appellate judges to go outside the record. And I sitting here today, I can't tell you a circumstance where I've seen it in my own practice, so I can't tell you what exceptions there might be to make that rare thing happen.
Yeah, the case that obviously comes to mind that has enormous impact on those of us in the political line of work is Citizens United, which allowed unlimited amounts of money into politics on the premise that all of that spending was going to be transparent and therefore would not contribute to corruption or the appearance of corruption of the political system. And of course, it's indisputable that it has been anything but transparent. We're well through $1 billion in anonymous political funding. So that fact that Justice Kennedy stood his decision on is simply provably false, which then raises the question, now what do you do about that decision? If that fact was the hinge upon which the decision swung, and the fact is false, where do you go?
Well, Senator, for lower court judges, we can't go anywhere, really.
Yeah, even when it's fact-finding. I mean, you're supposed to agree with the legal determinations of the Supreme Court and to follow them, but it's an interesting question whether a false factual determination by the Supreme Court merits similar deference or the deference that separation of powers puts the legislative and executive branches under with respect to a Supreme Court decision. It's something to ponder because it has not been the custom of the court to engage in this free-range fact-finding, and particularly false free-range fact-finding, but some of the political decisions of the court have stood on false free-range fact-finding, and it raises this whole new interesting set of questions about what do you do when the Supreme Court has made a factual determination that is not supported by any record, that is provably false, that is essential to the logic of their decision. Is it really true that all of government is powerless to address that error? So I have used my time, something for you to ponder as you move towards your seats on our circuit courts of appeal, which I will strongly support. Thank you.
Thank you, Senator Whitehouse. Senator Lee.
Thank you, Mr. Chairman. Thanks to both of you for being here today and for your willingness to serve on our judiciary, if confirmed. I'm going to dive right in. I've got a number of questions. We'll start with you, Ms. Akumi Jackson. It's been widely reported that President Biden met with you in anticipation of your nomination to the U.S. Court of Appeals for the Seventh Circuit, and congratulations again on that nomination. During that meeting with him, were you asked for commitments regarding, or did you discuss abortion or Roe versus Wade, Second Amendment, or D.C. versus Heller, efforts to defund the police, illegal immigration, any of those issues?
None of the above, Senator.
Okay. Judge Jackson, what about you?
No, sir.
Okay. Judge Jackson, in your notes for a presentation that you gave at Columbia Law School in 2019, I believe, you said that, quote, disparities in judicial outcomes can also occur when judges consider legitimate and relevant factors, close quote. Talk to me a little bit about what that meant.
Thank you, Senator. That presentation was a symposium that I'd been invited to comment on an article that was being presented. And the article itself was about judicial bias. And I was critiquing it and making arguments in response to it based on my experience. And I believe that I would have to see exactly the context of the quote that you read, but what I was suggesting was the idea that because the factors in the law concerning something like sentencing are open-ended, that Congress says you have to sentence defendants to terms of imprisonment that are sufficient but not greater than necessary to promote the purposes of punishment. And it lists the purposes of punishment. And any judge who looks at that has basically those broad parameters within which to think about how they're going to sentence. But the judge then will have to decide whether they're thinking about deterrence or retribution or various purposes in order to determine how they're going to sentence. And my idea was that a similarly situated judge looking at the exact same set of facts, applying those factors in 3553A, could reach a different result. So that you're going to have sort of inherent in the nature of judicial exercise of discretion in the world of something like sentencing, disparity, unbeknownst.
No, that's helpful.
Yes.
Now, I believe you've been a judge now for about 8 years, if I'm not mistaken. In your experience as a judge, and prior to that, your experience as a lawyer, would you agree or disagree with someone who said that most racial disparities in criminal convictions and sentencings result from an unconscious racial bias of judges, juries, and other judicial decision makers? Would you agree or disagree with that statement?
Well, Senator, let me just say that as a judge now, it's very important for me not to make personal commitments about things like the question that you asked, that my personal views about anything don't impact my rulings. I am aware of social science research. There is a professor at Harvard, Professor Banerjee, who has done implicit bias work. And there are studies from the commission when I was back at the commission in the policymaking role that talked about and indicated that all of us human beings can have biases that we are unconsciously operating on, and that we have to think about that when we are making decisions, and especially policymakers in the criminal justice system.
Now,
I'm aware of those studies, but I'm not a social scientist, so.
No, I understand that, and I'm just asking for your overall sense as a judge, and certainly not for a commitment or social science. In 2019, I think in connection with with notes prepared in connection with the same speech, you noted that, quote, observed inconsistencies are largely attributable to factors other than group-based bias by judicial decision makers. Does that ring a bell? Is that something you
Yes,
stand
in the
by?
context of the critique that I was making, because the article had indicated that they saw, they showed research that there were these demographic disparities, and the article said that they were attributable to bias.
Right.
And so I was trying to give another perspective.
Right. So what are some of the leading factors that is other than unconscious bias that you see having an impact there, that account for some of the disparities that we see in convictions and in sentencing?
Well, one of the things that I was aware of in my time on the Sentencing Commission, and is something that you all have worked on, were the differences in statutory penalties for things like crack and powder, that many
Vast disparities between what you get sentenced for with crack versus
correct,
powder cocaine.
and that it was having a demographic effect, because the research and statistics showed that an overwhelming number of defendants who were convicted of crimes involving crack were African American.
Thank you, and that is very helpful. I do want to make sure I get to one other thing I wanted to talk to you about before I run out of time. You've remarked that presidents are not kings. That's a comment that I've made a number of times as well, and tend to agree with it. Whenever you're sitting in any court, from time to time you have to review executive actions. It seems like executive actions have more of a likelihood of coming up in the U.S. Court of Appeals for the D.C. Circuit than many other places. You think it would be appropriate, under the guise of prosecutorial discretion, for any president of the United States to tell an agency not to enforce a particular law?
Senator, I'm unfortunately not going to be able to engage in a hypothetical discussion precisely because those kinds of matters might come before me, and I don't want to prejudge any case that might involve those facts.
Okay.
I do understand the implications of the law related to it, but I can't tell you whether it would be appropriate or not.
Okay. I'd love to delve more into this. I see my time's expired. Thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you, Senator Lee. Senator Klobuchar.
Thank you very much, Mr. Chairman, Ranking Member Grassley, and congratulations to both of you for your nominations and for your incredible work. Judge Jackson, the last time that you were here in December 2012, then Representative Paul Ryan introduced you. You remember that?
I do.
Okay, saying our politics may differ, but my praise for her intellect, for her character, for her integrity is unequivocal. On March 23, 2013, you were confirmed by the Senate by voice vote and have since presided over many jury trials, bench trials, and written 562 opinions. What have you learned during your time as a district court judge that will inform your service as a judge on the D.C. Circuit?
Thank you, Senator. I've been very fortunate to work in a wonderful district with terrific colleagues, and what I've learned is a lot about agency practice. As has been previously mentioned, I did not do agency work in private practice or in my role as a federal public defender. And so I've learned a lot about how our government works in talking with my colleagues, and I'm looking forward to, if I'm confirmed, being in constant communication with other judges in looking at some of these very, very complicated issues concerning our government and its operation. I've learned the importance of having a collegial relationship with your colleagues on the bench, and I look forward to continuing that in my role as a circuit judge if I'm confirmed.
Very good. And over the course of your service as a judge, you've ruled both for and against the government, including in Center for Biological Diversity, that case where you be McClellan, where you rejected a challenge by groups opposing the previous administration's plan to build a wall along the southern border. How do you ensure that you impartially review the facts and law when approaching a case? And how will you apply those principles as a circuit court judge?
Well, Senator, I try to stick to the same methodology in my rulings. I try to focus, I do focus on the arguments, the facts and the law, the binding precedents of the Supreme Court and the circuit. And I very methodically work through an analysis of those issues, of those inputs in every case. And that helps me to not pay attention to who is involved, whether it's a government that is being run by one administration versus the other. I'm just focused on the arguments that are being made. And it's funny because my clerks sometimes, they say, your opinions are all the same. Elementally, they all look the same. And I say, yes, exactly. That's the point. That's what I'm trying to do, to make sure that I'm treating everybody equally and I'm not paying attention to who's in the administration when I'm ruling on a case.
Very good. Thank you very much for that answer. Ms. Jackson-Akiwumi, again, congratulations to you. You spent many years working as an advocate for various clients in both criminal and civil cases with a breadth of experience. If you are confirmed to serve on the Seventh Circuit, which I very much hope you will be, you will have to impartially apply the law. Can you say more, and I know you talked a little bit about your experience, but could you talk about how you view the role of a judge and how it differs from that of an advocate? And do you have any reservations about being able to set aside your past advocacy when analyzing a case?
Thank you, Senator Klobuchar. As you indicated, I've had a variety of different roles throughout my career: civil litigator at large law firms, at a small law firm now where I'm a partner or smaller, federal public defender, law clerk to 2 federal judges. In each of those roles, I've had to get up to speed in a variety of new areas of law and represent different types of clients. Corporations, nonprofit organizations, individuals. I have enjoyed the challenge and the variety, and that's what I fully expect to encounter on the circuit court if confirmed. So I believe that will be a transition that I'm up to, and I also am fully confident that I can apply the law neutrally and fairly as a circuit judge. As I indicated in one of my earlier answers, being an advocate requires you to work within the framework of existing law. You can't go off on your own. And so I'm prepared to work within the existing framework of Seventh Circuit precedent, Supreme Court precedent, in reaching reasoned decisions. And then finally, Senator, yes, I'm aware that the role of advocate and judge are so very different. As an advocate, your positions are essentially given to you, because you must create, you're coming up with the best arguments for your client, the best positions within the framework of existing law to advocate what's best for your client. As a judge, you don't come from that perspective at all. You approach each case open-mindedly, with an open mind, and you listen to the arguments of both parties without a thumb on the scale. You do the research. I'm familiar with the Fourth Circuit, the collegial atmosphere. You talk with your colleagues, conference with your colleagues, and then you work through the law to get to a reasoned result. And it's not at all dictated by a position that you started with.
Okay, very good. And I think that's a good description as well when you look at someone who served as a public defender, and people may, of course, not agree with some of the things that clients that you may have represented, or with crimes that were committed, but you have a job to represent them under the law. And I think it's that confusion of those issues that have sometimes led the Senate to not confirm some people. And I just see it as having been in the role of the prosecutor before, done a little bit on the public defender side, more pro bono. Just seeing that we have to differentiate that, or we'll never have anyone in these jobs that has been an advocate for clients on the criminal defense side. And I guess I'd end with that area. Judge Jackson, you spent 2 years as an assistant special counsel on the U.S. Sentencing Commission, later vice chair and commissioner. How has that experience informed your approach as a district court judge for sentencing principles, and how will that inform your work as a circuit court judge?
Well, thank you, Senator. One thing that the assistant special counsel did was to work on the actual drafting of the guidelines. And so even apart from the substance, just the meticulous work that was necessary to draft the guidelines has been helpful in my drafting opinions. And with respect to the substance, understanding sentencing policy and practice has really been useful for me as a trial judge, because as I said, I have sentenced more than 100 people, and you use the guidelines manual as the Supreme Court directs in order to do that. And so I came to the job with a sense of what sentencing was about. And I think that for appeals, my experience in actually engaging in sentencings and understanding trial procedures from the trial court perspective would be very helpful, because the Court of Appeals reviews trial court proceedings and sentencings in criminal cases And I think that that perspective should be valuable if I were confirmed.
Thank you very much. Thank you to both of you.
Thanks, Senator Klobuchar. Senator Cotton?
Congratulations to you both on your nomination. Is it Judge Brown Jackson or Judge Jackson?
Jackson, please. Thank you.
Judge Jackson. In your career before you were a judge, have you ever represented a terrorist at Guantanamo Bay?
About 16 years ago, when I was a federal public defender.
Okay, and was that case assigned to you as a federal public defender?
It was?
Who was the client that you had?
Oh, Senator, I don't remember the name.
Okay, could we get that for the record, please?
Sure.
Thank you. Ms. Jackson-Akumi?
Jackson-Akiwumi.
Akumi.
Thank you.
Want to make sure I get it right. In your legal career, have you ever represented a terrorist at Guantanamo Bay?
No, Senator.
Thank you. I want to speak about race discrimination in the Constitution. Ms. Jackson-Akumi, does the Constitution allow the government to treat Americans differently because of their race?
No, Senator.
Thank you. I'm glad that we agree on that. Judge Jackson, could I get your hand?
No, Senator.
Thank you. Let's turn to religious liberty, if we can. The First Amendment protects the freedom of religion. This also means the government can't institute blanket policies that treat religious organizations, such as churches, worse than they treat secular organizations, such as restaurants or clubs or casinos. Is that right, Ms. Jackson-Akumi?
Senator, the First Amendment protects religious liberty, religious freedom, exercise of religion, and all of those issues are being actively litigated right now, including at the Supreme Court.
But the government can't treat a religious organization worse than they would a secular business, like a restaurant or a casino. Is that correct?
Senator, you're referring to the principle about neutral laws, and that there is a principle there that if a law is neutral as to everyone, a religious organization can be included. And it's my view that the Supreme Court is testing the areas of that. For example, the Supreme Court recently granted an injunction out of California that involved one of those issues. So I just wanted to be sure to reflect the nuance there, Senator, and the fact that the Supreme Court is working through those issues. And I'll also add that First Amendment litigation has not been my area of practice the last 10 years or even 16 years. But that's my broad understanding of what's happening with the clause right now at the Supreme Court.
Thank you. Judge Jackson?
Yes, Senator. I, too, have not had many cases involving religious liberty issues. I have one right now that might involve some of these issues, but I am aware that the Supreme Court has rightly viewed the First Amendment right to religious liberty as foundational, fundamental. It's in the First Amendment, and the Supreme Court is working through the doctrine. There's been a series of cases in the last few years as the court determines what it means to treat religious organizations differently.
Thank you. Let's turn to the Second Amendment, Ms. Jackson-Akumi. Do you believe the Second Amendment protects an individual's right to keep and bear arms for self-defense?
Senator, the Supreme Court has said that very clearly. That was Justice Scalia writing in Heller, that the Supreme Court protects an individual right to keep and bear arms.
Which has been extended to the state and local governments through McDonald, correct?
That's correct, Senator.
Okay. What do you believe are the limits on that right?
Well, that's the very thing that circuit courts across this country and the Supreme Court are figuring out right now.
Do you have any personal views on that?
Well, if I had any personal views, they certainly wouldn't be relevant to decision-making that I would engage in as a circuit judge. If confirmed, I would be bound by the Supreme Court's precedent in Heller, in McDonald, and any of its progeny that develops.
Okay. Judge Jackson?
I agree wholeheartedly with what Ms. Jackson-Akiwumi said. Any personal views regarding the fundamental right to bear arms would have no bearing on my decision-making concerning those issues, and I would be bound by the Supreme Court's and the DC Circuit's precedents concerning the issue.
In Heller and McDonald?
In Heller, McDonald.
Thank you. Ms. Jackson-Akumi, do you agree with Justice Stephen Breyer and the late Justice Ginsburg that the Supreme Court should have 9 justices and justices should not be added?
Well, Senator, I will have to admit that I'm not familiar with their particular views on that issue, and I don't think it would be appropriate, as I indicated in a question from your colleague, for me to opine upon the composition of the Supreme Court or what should or shouldn't happen. It is a question that this body must sort through. It's a question left to the legislative branch and the executive branch.
Yes, Senator, I'm currently...
I won't even ask since you're sitting.
Okay, thank you.
All right. Thank you both for your testimony today, and congratulations again.
Thank you.
Thank you, Senator Cotton. Senator Coons.
Thank you, Chairman Durbin, and welcome to our 2 nominees who are before this committee today. Both of the nominees before us are highly qualified and impressive candidates, and both have demonstrated a commitment to justice and fairness throughout their extraordinary legal careers. Judge Jackson, some critics have pointed to cases where you ruled against the Trump administration and somehow suggest that is evidence you are biased. A review of your actual record shows you've ruled both for and against administrations of both parties, even on some pressing and important legal matters with political overtones. Could you speak about some of these examples and how it is a mischaracterization of your judicial record to simply look at your record in the last 4 years?
Well, thank you, Senator. I tend to leave it to others to characterize my record. I am doing the work of analyzing the arguments and the facts and the law in every case.
Can I reframe that?
Yes.
That'd be helpful, thank you. If we try to assess a judge's record simply based on sort of a scorekeeping of which administration either they were confirmed under or they rule for or against, what does that miss about a judge's judicial philosophy and qualifications? And is that an adequate way to assess how you, as a nominee for an important circuit seat, would approach a case?
Well, I do think it misses quite a bit because as I am applying a methodology as I go through my cases, and it involves fastidiously looking only at the arguments that the parties are making, the facts, and the law. And sometimes those arguments are being made by one party or another in a government case, but that doesn't matter because I'm testing out the merits of the claims that are being made and how the law, the binding law of the Supreme Court and the DC Circuit applies to those claims in light of the facts. If you look at a judge's body of work, you will see that the claims and the law and the facts don't vary really based on party. And so sometimes you're going to find cases in which the judge might rule in favor of one administration. Sometimes you might find against. That's not what is the driving force behind the judge's rulings. I have had cases, many cases in fact, that I can think of in which I've ruled partially for one party or the other, so that party meaning a party in the case, not a political party, so that it's a split decision, and both parties in the case are upset at the end of the day, but it's because that's what I believe the law required. And so if the judge is going to do their duty, they're not focused on the same political dynamics that you're talking about that other people try to find in their rulings.
Can you both, but I'll ask you to go first if I could, Judge Jackson, just speak to the value of an independent judiciary, one that's insulated from temporal, partisan, political considerations?
Well, Senator, I think it is one of the bedrocks of the rule of law, which, as you know, is a foundational constitutional principle. It is what everything in our government is really erected around. And if you don't have judges who are able to do their duty, their Marbury versus Madison, saying what the law is independent of the political branches, then we've lost that very important check that the founders wanted us to have. It's the way our government was constructed. And so the independence of the judicial branch is crucial.
Thank you. Ms. Jackson-Akiwumi, would you also care to comment on the significance or importance of a federal judiciary independent from the sort of winds of politics?
I will say, Senator Coons, it's hard to improve upon the answer that Judge Jackson just gave. And I will also add that I've clerked for 2 federal judges, and every single judge I've ever appeared in front of seemed to understand this foundational principle about their independence. It does not seem to be in dispute among the judges I've appeared in front of and worked for.
My understanding is both of your parents were also judges. Could you just fill me in briefly on what motivated you to pursue a career in service, and in particular in the law?
Thank you, Senator. It is true, I grew up in a family that very much valued public service. I always knew that the bulk of my career would be spent working in the public interest, so I'm honored to have this opportunity and the faith of the President and our community in returning to public service. It's simply an honor. My parents have taught me a lot throughout my life. In terms of their judicial careers, I certainly witnessed my father do the very thing you just finished discussing, rule without fear or favor and understand his independence. I watched my mother put litigants first. Even at risk of her own body, she sat for hours on the bench because she knew that litigants had taken time off from work to come to court. Police officers were away from their beat. Caregivers were away from their families, and she did not want to delay the administration of justice, so she sat for hours without taking a break. So I learned a lot about service from my parents and judicial service long before the thought of serving our country in this way ever came to me, long before I was presented with this opportunity by our president.
Last question. You would bring some badly needed diversity to the Seventh Circuit of several kinds. The Cato Institute had a study that showed there was 4 times as many prosecutors as defense attorneys in the federal judiciary. And in terms of background, life experiences, upbringing, racial, gender background, having a more broadly diverse federal judiciary is a goal of this administration, and certainly one that I strongly support. Could you just speak briefly to what difference does that make, and why is that a value, professional experience and background diversity for our federal judiciary?
As I indicated earlier, demographic diversity and professional diversity certainly increase public confidence in the court and our court system. People can accept decisions as more fair, knowing that a broad array of judges have considered the matter and the courts aren't restricted to just some. There's an important role modeling function so that young people in our country, young students, law students, young lawyers, know that the path of public service on the bench is open to everyone, not just those who've taken a certain career path. And then I hope to be able to bring something to discussions with my judicial colleagues, if confirmed, because of my experience. Just in the way, I'm aware of the collegial nature of our circuit courts. And from clerking, I'm aware that judges conference after oral arguments to discuss their impressions about any particular case. And just like a colleague with a background as a state court judge might notice one fact in the record and want to discuss that, or a colleague with a background in mergers and acquisitions might notice another fact in the record and want to discuss that, or a prosecutor, still yet another fact, I hope that I too can bring something to our discussion because of my experience as a federal public defender, and thereby enhance our collective discussion and decision-making.
Well, thank you both. I really appreciate your answering my questions. I look forward to supporting your nominations. Thank you, Mr. Chairman.
Thank you, Senator Coons. Senator Hawley.
Thank you, Mr. Chairman. Thank you to the nominees for being here. Congratulations on your nominations. Ms. Jackson-Akiwumi, if I could start with you, I want to ask you again about the Reginald Taylor case in which I think you served as a defense attorney. This was an armed robbery case. I want to ask you about your sentencing memorandum in this case. You argued in that memorandum that the defendant should not be subject to the 15-year mandatory minimum for the armed career criminal minimum, that is, should not apply to this defendant. It was a mandatory minimum. So just walk me through this. What was your argument about not applying a mandatory minimum sentence? Is it your view that judges should be free to depart from those mandatory minimums? Just help me understand your argument there.
Thank you, Senator, for the question, the opportunity to address that. That argument was based on the Armed Career Criminal Act, which stated, Congress stated, that defendants should only be subject to the mandatory minimum if they had certain predicate offenses in their criminal history. The predicate criminal offense that the government relied on in Mr. Taylor's criminal history was residential burglary. The Supreme Court and the Seventh Circuit and many circuits around the country were working through the issue of whether residential burglary qualified as a predicate offense. We took the position that residential burglary did not qualify as a predicate offense. And if it did not, that meant the mandatory minimum of the Armed Career Criminal Act would not apply in Mr. Taylor's case.
Very good. That makes sense to me. Let me ask you about something you wrote in that same sentencing memorandum. You wrote that this departure from the mandatory minimum was appropriate because, and I'm quoting now, when black defendants continue to receive longer sentences than white defendants for the same crime, no additional time should be added to further entrench this disparity, end quote. Is it your view that the Armed Career Criminal Act or mandatory minimum sentences in general are racist and inherently racially disparate?
Senator, thank you for that question as well. There has been research by the Sentencing Commission and other agencies in our government that have shown, the research has shown the racial impact of mandatory minimum sentences. It's an issue that this body and this very committee has considered. What I was referring to in the portion of my sentencing memorandum that you quoted is the Supreme Court law, there's Supreme Court case law that says above and beyond a mandatory minimum, a judge does not have to impose any additional time. If the judge, in her discretion, feels that the mandatory minimum will impose what Congress has stated the standard is, a sentence that is sufficient but not greater than necessary, then the judge does not have to add time on top of that. And so the argument that I was making to the judge was, look, court, if you feel the mandatory minimum imposes a sufficient but not greater than necessary sentence on Mr. Taylor here, please do not add additional time on top.
Let me ask you a question that I've asked other nominees that have come before this committee. Do you think that the U.S. criminal justice system is systemically racist or is infected with systemic racism and bias?
Well, Senator Hawley, those are not terms that I use. In the law, when we look at issues of race, we look at discrimination, which has very specific standards under Supreme Court and statutory law in terms of making findings. And so courts will be generally looking for attorneys to prove up discriminatory intent, discriminatory impact, in some cases retaliation. There's no Supreme Court doctrine that speaks to systemic racism, and it's certainly not there certainly aren't words that I've ever used in a court of law to make claims based under the Constitution or the applicable statute.
And those are, just to be clear, those are not words, descriptors you would use to describe our criminal justice system as it currently exists.
That is certainly not the way, as an advocate, I would be able, under the law, to approach any case involving race.
Very good. Let me ask you about the Adam Walsh Child Protection and Safety Act. In a presentation you did for the Illinois Institute of Continuing Legal Education, you stated at the time that the law includes a new mandatory condition of electronic monitoring for all persons who are charged with a long list of sexual abuse or pornography crimes, including failure to register as a sexual offender under the appropriate statute. Now, in your presentation to other defense counsel, you noted that a number of district courts had found this act unconstitutional as a violation of the excessive bail clause of the Eighth Amendment, procedural due process grounds under the Fifth Amendment, and separation of powers doctrine. So I just want to ask you about this, since you were advocating making these arguments to other defense counsel. Do you believe that the Adam Walsh Child Protection and Safety Act is unconstitutional on Eighth Amendment grounds?
Sitting here, Senator, I actually can't remember that presentation that you're referring to or anything I might have said in that presentation. What I can tell you is that if confirmed as a judge, I am certainly bound by the statutes of this body and would be called upon to apply them to the facts of any case that's before the Seventh Circuit.
Very good. And I wanted to ask you the same question about the statute being unconstitutional on Fifth Amendment grounds or separation of powers grounds. Is your answer the same for those as well?
Yes, Senator. I'm sorry. I don't recall that presentation or the content.
That's fine. What we'll do is I'll give this to you as a question for the record, which will give you opportunity to go back and look at your notes, and you can get back to us on that once you've had a chance to review. Just in my final moments, I wanted to say, Judge Jackson, that I noticed, I think I'm right about this, that you served some years ago on the board of Montrose Christian School. Is that right? Have I got that right?
Yes, Senator, for about a year.
Got it. Well, I mention it because I noted in the board's statement of faith at the time, it said that we should speak on behalf of the unborn and contend for the sanctity of all human life from conception to natural death. It went on to say that children from the moment of conception are a blessing and heritage from the Lord. The school also took the position that marriage is the uniting of one man and one woman in a covenant commitment for a lifetime, and that the state has no right to impose penalties for religious opinions of any kind. Now, those are positions that I happen to agree with, which is beside the point. I raise them because I distinctly recall that Justice Amy Barrett was attacked for serving on the board of Trinity Schools, which took similar positions. I defended her at that time. I'd certainly defend your right to religious liberty and to serve on this board, whatever your opinions may be, at the same time. And I take it that from your service that you believe in the principle and the constitutional right of religious liberty. Is that fair to say?
Well, Senator, I do believe in religious liberty. That is a foundational tenet of our entire government. Our constitutional scheme. The Supreme Court has made clear through its case law that governments can't infringe on people's religious rights. Those ideas, that concept comes from my duty to observe Supreme Court precedent, to follow its tenets, not from any personal views that I might have. And any personal views about religion would never come into my service as a judge. I would also say that I've served on many boards and that I don't necessarily agree with all of the statements of all of the things that those boards might have in their materials. The statement that you read, I'm not even sure that that was something that was in the school's circumstances at the time that I was there, because I was not aware of that. But in any event, I do believe in religious liberty, yes, Senator.
Thank you very much. Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman. Thank you both for your willingness to serve. Thank you to your families who are undoubtedly very, very proud of you, justifiably so. And I'm proud to be here as a member of the Judiciary Committee to be involved in your confirmation. I will support you because you are both superlatively well qualified by your academic background, your professional standing, your service to our nation, and your families. So I want to just begin by saying that you both have backgrounds as public defenders. I served for 4.5 years as United States Attorney in Connecticut, Chief Federal Prosecutor. I then was Attorney General of our state for 20 years, involved in law enforcement. And I really welcome the President's emphasis on elevating and showing that public defenders are as deserving, by virtue of their background, to appointment as a federal judge, as a prosecutor, as anyone else. I know that the positions are very competitive now, but public defenders bring a perspective to judging that prosecutors may not, just as people who come from private practice bring a different perspective. So I congratulate and thank you for your backgrounds as public defenders. And likewise, I think diversity is very, very important on both of the circuits that you will join. The Seventh Circuit presides over 7.5 million people of color, and its jurisdiction includes Chicago, Milwaukee, and Indianapolis, among other cities, yet all of the judges currently sitting on the court are white. In 2021, I am dumbstruck. It's breathtaking that a federal circuit court in any part of our country is all white. And I've remarked on this point before, just to say it again, thank you to the President, thank you to you for helping to correct this injustice, which undermines the faith of the public in our judiciary. The reason that we are still as strong and resilient as we are as a democracy is because of an independent judiciary that has had the courage to stand up to the kind of potential abuse in our democracy that we've seen, the contempt for the rule of law that we've seen at the highest places in a past administration. I want to avoid unnecessarily going into politics here, but I do think that we are at a moment when we need to thank the judiciary as an independent branch of government, most especially our district courts, our courts of appeals, for continuing to stand strong for our democracy. So I am proud to support you, and I just want to ask each of you roughly the same question I asked Judge Jackson 8 years ago as a nominee for the district court about your positions on sentencing discretion. This issue is critically important now as we approach the Justice in Policing Act and possible revisions to our law to make it fairer and more just. Sentencing is an enormous power. You won't have it as circuit court judges, but I would be interested in your views as to when departures from the sentencing guidelines are justified and some of the more common reasons there ought to be for departing from those sentencing guidelines. Perhaps you could give us the benefit of your experience on that point.
Well, Senator, thank you for that question. The sentencing system has gone through different phases, and we're now at a point in which not only do we have the guidelines manual and the departures that are in the manual, but as a result of the Supreme Court's decision in Booker, now judges can use the guidelines as a starting point for their analysis, and they can determine whether the guideline sentence and any departures are sufficient penalty for the case. What that has meant is that in some districts, judges don't depart in the same way. The departures are grounds within the guidelines manual for imposing a sentence that is different than the one that comes out just from the initial calculation. And in the guidelines manual, there's a lot of room for judges to take into account certain factors concerning the circumstances of the individual in departing. But in my district, I know that judges tend to what we call vary from the guidelines as well, in circumstances in which, let's say, the age of the person may mean that the guideline penalty is too much. There are lots of different reasons. Mental health reasons are in the guidelines, but they tend to be factors that have to do with the individual. And then there's also the most prevalent departure, which is one that the prosecutors actually recommend in a situation in which a person is cooperating. So all of those factors enable judges now in our system to impose sentences that are sufficient but not greater than necessary. But Congress, obviously, as the policy-making body, has to continue to evaluate whether any changes need to be made.
Thank you. Jackson-Akiwumi.
Senator Blumenthal, this is my second time saying it today, but it's hard to improve upon that answer that very comprehensive answer that Judge Jackson gave. She accurately described the sentencing regime I litigated under for a decade. And in almost every case, I will say, where judges departed from the guidelines and I was representing a client, it was because of the presence or absence of mitigating or aggravating factors. And so there would be aggravating factors that warranted, in the judge's mind, a higher sentence, guideline sentence, in the rare case, and in the more common case, mitigating factors that warranted a sentence lower than the advisory guideline range. And in all of those cases, the judges were still operating under the statutory framework that this body laid out about how they should sentence. And only one of those many statutory factors was the sentencing guidelines. So there are many other things that judges needed to look to. Thank you.
Thank you very much. Thank you, both of you, and thank you, Mr. Chairman.
Thanks, Senator Blumenthal. Is Senator Tillis available remote?
I am, Chairman.
Please proceed.
Thank you, Mr. Chairman. To Judge Jackson and Ms. Jackson-Akiwumi, congratulations on your nomination. I'm sure your family and your friends are very proud of you, and rightfully so. But Mr. Chairman, I think it's important to highlight one of the key reasons why we have these nominees before us today. The group demand justice, a group I've spoken about in this committee before, and I spoke about it when Senator Whitehouse held a hearing on the issue of dark money campaigns behind judicial nominations. That group is largely responsible for the nominations that we have before us today. Demand Justice is a dark money liberal group whose first priority is getting left-wing judges who will follow a liberal agenda instead of the Constitution, if confirmed. I should also add Demand Justice is spending millions of dollars advocating for the expansion and the packing of the Supreme Court. In fact, they've been pushing for liberal judges since before President Biden was even elected. Like many of us last year, Demand Justice called on candidate Biden to release a potential list of Supreme Court nominees, but he refused. However, Demand Justice released a list of their preferred Supreme Court nominees. The short list was first released in October of 15, 2019. And without objection, Mr. Chairman, I'd like to submit two documents that were on the Demand Justice website for the first and the second list that I'll talk about in a moment. The first list contained 32 names of bold progressive leaders who would help rebalance the Supreme Court. According to Demand Justice, their list included lawyers who have championed progressive values as public defenders, public interest lawyers, scholars, plaintiffs' lawyers, and elected officials. However, the two nominees before us today were not on the first Demand Justice list. But in April of 2020, Demand Justice released a second short list of their Supreme Court nominees for soon-to-be President Biden to pick from. Both Judge Jackson and Ms. Jackson-Akiwumi were on this list, on the second list from the demand justice. And now they're sitting in front of this committee today as nominees to circuit court positions. So what changed between the first demand justice list and the second one? In Judge Jackson's case, roughly 1 month after the first demand justice Supreme Court short list came in, Judge Jackson, issued a ruling in a case brought by House Democrats who wanted to compel former White House counsel Don McGahn to testify. While we can debate the conclusions of Judge Jackson that Judge Jackson made, one thing is clear. The 120-page ruling had a purpose. I think Rachel Maddow explained the purpose of the 120-page ruling well. If the production crew can run the video clip of Ms. Maddow, do so now.
The judge, in this case, Judge Ketanji Brown Jackson, tonight has ruled against the president and has ruled that in this specific instance, the official that the president has instructed to defy the subpoena, former White House counsel Don McGahn, the judge says Don McGahn must comply with that subpoena and he must turn up to Congress to testify. And this is a long ruling tonight. But it's interesting. It seems to me like it is written with a broad audience in mind, because it's not a super legalistic thing. It's not just a mechanistic order that McGahn has to show up and here's the precedents that lead to that and so forth. This is the kind of court order, the kind of judicial ruling that is, if this were an indictment, you'd call it a speaking indictment, right? This is a ruling that is designed to be read by people who are outside this case.
So just to repeat some of the comments, the ruling was written with a broad audience in mind. It's not just a legalistic thing, kind of a judicial ruling, that is. If this were an indictment, it would be a speaking indictment. This is a ruling designed to be read by people outside of the case. This case was 1 month after Demand Justice Supreme Court shortlist came out. The Demand Justice released their second Supreme Court shortlist in 2020, and Judge Jackson was at it. How is this any different from what Democrats have accused Republicans of for the last 4 years? Or is it suddenly okay when it is liberal dark money, a liberal dark money group, picking the nominees for the highest courts in the country? Mr. Chairman, again, I would like to have or seek unanimous consent to add the 2 shortlists from the Demand Justice website, and thank you.
Without objection, they will be added. Does the Senator have any further comment or questions?
No, sir, I'm clear.
Senator, I'm going to ask Judge Jackson if she'd like to reply to your your comment. It was not a question, and it'll be your decision. Judge Jackson.
Yes, thank you, Mr. Chairman. I've been a federal judge for 8 years, and I have a duty of independence. I clerked for 3 federal judges before I became a judge, and they were models of judicial independence. And what that has meant is that I know very well what my obligations are, what my duties are, not to rule with partisan advantage in mind, not to tailor or craft my decisions in order to try to gain influence or do anything of the sort. I have no control over what outside groups say about my rulings. I have no control over what reporters say about my rulings. And to some extent, all of my 560 opinions are written for people outside of the case. They're written for the public, they're written for the appeals court, and they're written for the parties. So my statement is that I've always been an independent judge, and I believe that that is one of the reasons why the president has honored me with this nomination.
Judge Jackson, I said from the onset that it was one of the factors, not all of them. I'm sure your jurisprudence weighed into it, but your response would read almost identically to dozens of judges who came before the judiciary and they were rejected out of hand. The fact of the matter is, dark money is influencing it. Demand Justice is trying to expand the Supreme Court. So you can understand, after 4 years of hearing how the Federalist Society and other organizations were a dark money group with malign intentions, a group that is very much supporting you, why we would draw the same conclusion. Thank you, Mr. Chair.
Thank you, Senator. And let me just add one other element. I didn't want to incorrectly infer this, but I want to make it clear. This hearing was scheduled today not because of any plea by any special interest group at all. The nominees go through an extensive background check. All of them do. And it takes some period of time before that is completed and submitted to the committee, to both sides of the committee, Republicans and Democrats. And we have scheduled the 5 judicial nominees today as soon as that process had been completed. And it takes some time. I'm sitting here looking through your questionnaires. I don't know how you managed to accumulate all this information in response, but it was a good faith effort, I'm sure, to comply with everything under the law. And as soon as it was ready, we set this hearing. No outside group demands or pleas had anything to do with the timing of this hearing. Senator Hirono, are you available by remote? It's your turn.
I am. Thank you, Mr. Chairman. Democrats have long criticized the role of dark money in politics and certainly in judicial nominees. So if what I'm hearing is that our Republican colleagues are now on the same page with us in criticizing dark money, then we should all be voting for legislation to require disclosure of dark money sources. I welcome that change from the Republicans. I congratulate our 2 nominees. You are eminently qualified. That is why the president nominated you for these important judicial positions. So again, I congratulate both of you. I ask the following 2 initial questions of every nominee who comes before any of the committees on which I sit. These questions are, first question, since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No,
I'd like each of
Senator.
you to respond.
No, Senator.
Next question, have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
No, Senator.
Both of you have served as public defenders, and you've been asked some questions about that. And for Ms. Jackson-Akiwumi, in 2014, you gave an interview to Yale Law Women in which you discussed being a Black woman attorney. You described the burden you carry, like when a prosecutor accused you of being overly aggressive and yelling just because you forcefully made a point. But you also described the benefits. You said, well, sometimes my clients' families are very grateful to see me, a young Black woman in a position of power. I can inspire a client's child without even knowing. You are nominated to fill a seat in the 7th Circuit, which would make you the first Black person of color on the bench. What is the significance of that fact to you?
Thank you, Senator Hirono. I want to note I would be the 2nd person of color nominated to the 7th Circuit. Judge Ann Claire Williams served ably for decades and retired in 2017. I indicated earlier, and I stand by it, that there is the same role modeling function that I played when I was an advocate and that I was referring to in that interview. Oftentimes you can inspire a client's child without even knowing it, because it might be the first time that they've seen a Black woman standing up in court before the bench. And the same would be true if I were confirmed as a judge. I could serve as a role model for any number of people coming behind me, and that's not limited to people of the same race or same gender. One can inspire any number of people, and I would hope to do that through my service if confirmed.
I very much appreciated your noting the importance of demographic diversity and professional diversity, such as being a public defender, to achieve role modeling that you speak of. This kind of modeling truly should reflect the diversity of our country. I very much appreciate your saying that. Getting back to both of you serving as public defenders, these are highly competitive and difficult jobs. I'm sure you could have been gone to the prosecutor's office, et cetera. We rarely have considered public defenders, defender nominees in the Judiciary Committee. Can you talk a little bit more, both of you, each of you, on why you sought out these positions as public defenders?
Well, Senator, my service as a public defender was a while ago. I'm trying to think back on my reasons. I had come from a staff position on the Sentencing Commission and was working on a sentencing policy. And I remember thinking very clearly that I felt like I didn't have enough of an idea of what really happened in criminal cases, and I wanted to understand the system, if for no other reason than to be a better policymaker at the end of the day. Although I didn't end up ultimately doing that, and I thought it would be a good opportunity to help people as well. I come from a background of public service. My parents were in public service. My brother was a police officer and in the military. And being in the public defender's office felt to me very much like the opportunity to help with my skills and talents.
It sounds as though it's the kind of experiential diversity that was mentioned. I think that's also really important to understand that the people who come before you and whose lives you can impact with your decisions. Would you like to also respond, Ms. Jackson-Akiwumi?
Thank you, Senator Hirono. When I initially applied to become a federal public defender, I was looking for a job where I could help protect constitutional rights and work in that realm. I was really looking forward to being a trial litigator and an appellate litigator. At the Federal Defender Program in the Northern District of Illinois, we represented our clients from arrest all the way through appeal, even when they wanted to petition for cert in the U.S. Supreme Court, which I did in 2 cases. And I was also looking to represent individual clients. At that time, I had been a civil litigator for 3 years, and most of my clients, at least on the billable side, were corporations, nonprofit organizations. I was only representing individuals through my extensive pro bono work at the firm, so I wanted to do it full time. Now, having had the benefit of 10 years of this kind of service, I see I was absolutely right about the reward that comes from helping our country to live up to its constitutional ideals in the Sixth Amendment, that everyone should have the assistance of counsel. And what I also did not appreciate when I began, but quickly learned over the course of that 10 years, was how gratifying it was to walk with someone through the toughest days and nights of their lives when they were being judged for the worst moments in their lives, and to serve as a guide, counselor, investigator, social worker, strategist, negotiator. There were so many hats, in addition to a trial litigator, appellate litigator, oral advocate, written advocate. There was no end to the variety of ways that I was being called upon to help people and to help communities, and also to even help victims, because the system works when everybody is ably represented. And certainly many of my clients were clients one day, but they had been victims the day before. And so it was a robust way to help our country live up to its constitutional values, and it was really an honor and privilege to do that.
Thank you.
Thank you,
Thank
Senator
you, Mr.
Hirono.
Chairman.
Appreciate it very much. Is Senator Blackburn available by remote?
Yes, I am. Thank you, Mr. Chairman.
Please proceed.
And I am so pleased that we have these 2 nominees in front of us today. And Judge Brown, I want to come to you first, if I may. I know you're fully aware that you are discussed regularly as a future Supreme Court nominee. Many of our Supreme Court nominees are they come from the circuit that you would be serving on. But we do have some that are advocating to pack the court and expand the court. And I know that has been discussed. I think Senator Cornyn talked with you about it earlier. This is something I see as a dangerous proposal because it would basically set up a judicial arms race. If somebody adds, somebody else is going to add. And we know that it is said that even President Roosevelt's threat and unsuccessful attempt to pack the court was enough to intimidate justices. So first of all, do you believe that deliberately expanding the court to allow one president to pack it with their nominees would undermine confidence in our laws and undermine the separation of powers? And then secondly, if they were to expand the court, if President Biden did that, would you accept a Supreme Court nomination under those circumstances?
Thank you, Senator. I am currently a sitting judge in the lower courts, and as such, I am bound by Supreme Court precedent and by Supreme Court rulings, and I don't think that it's appropriate for me to comment on proposals about the structure of the court, about expanding the court, or anything of the sort, just as it wouldn't be appropriate for me to talk about or critique or comment on Supreme Court precedent. So I'm unable to answer your
But
question.
you are aware that groups that are advocating for you support that?
Senator, there are lots of people who have expressed their support for me, and I'm gratified, but I'm really focused on this nomination, and I am hoping to be confirmed to the DC Circuit.
Okay. Ms. Jackson-Akiwumi, I appreciate the comments that you've had to say about diversity. I always say that having a good input, having good relationships with individuals who are different from me and who have different points of view from me is something that is important to help me in public policy and to do a better job in representing all Tennesseans. So I appreciate the comments that you have made there. And I also noted, as I looked through your record, that you've represented many different clients during your tenure with the Federal Defender Program, and you've been a zealous advocate for those clients. I want to draw attention to a case where you defended a man who preyed on women for sex, trafficked, prostituted them. His victims accused him of physically restraining them with a firearm, despite believing all women. You called these women liars to cast doubt on their testimonies and claimed there was no evidence from the victims' testimonies and their words were dishonest. In your sentencing memorandum, you further shamed the victims' alleged prior prostitution work to support a more lenient sentence for your client. So do you support believing survivors of sexual violence and crime?
Thank you, Senator Blackburn, for the question. I'm not sure which case you are referring to. As we've shown, I've represented more than 400 clients, and a number of those cases were sex offense cases. What I can say is that calling a victim a liar is not something that I've done in court or in written record. It is certainly my job as an attorney to examine the evidence and present questions about the evidence to the court where appropriate and where necessary. And then
let's do this. Let me give you the specific case and you can submit in writing, because your sentencing memo is something that does cause me concern. And we've been through a time where a previous Supreme Court justice Kavanaugh. During that, we've got an issue right now with Governor Cuomo, and whether knowing where you stand on that, I think, is really important. So I will get that to you in writing. Is that okay?
Thank you, Senator.
Thank you. I appreciate that. Judge Jackson, I want to come back to you. In 2019, you granted a preliminary injunction against a DHS rule expanding the use of the department's statutory authority to use expedited removal procedures. The DC Circuit then reversed your injunction and found that Congress granted the DHS secretary sole and unreviewable discretion on expedited removal determination to enforce our immigration laws. Since the beginning of President Biden's term, the amount of illegal border crossings has skyrocketed, and it appears that we will exceed everything that we hit at that border in 2019. Last month, border agents took over 170,000 migrants into custody at the southern border, including 19,000 unaccompanied children. These border apprehensions have hit a 15-year high. The Biden administration's flawed immigration policy has only encouraged more and more migrants coming to the country illegally. On top of that, the administration is failing to properly handle the surge in illegal crossings and has allowed our country's borders to be overwhelmed. They have even failed to acknowledge the crisis exists. The administration's failures have caused massive suffering and endangered communities, and anyone who has not been to that border needs to go. I was astounded. So, Judge Jackson, do our Homeland Security officials lack sufficient authority to act decisively and timely to keep us safe and enforce these immigration laws?
Thank you, Senator. I've had a number of immigration cases, and in those cases, like the one you mentioned, what I'm doing is I'm evaluating the law, the immigration laws, very complex scheme, the facts in the particular case and the claims that are being made, the arguments of the parties. I'm not assessing the policy. I'm not making a determination about sort of in a general sense of whether or not DHS officials have enough authority or any other sort of policy consideration. Given what it is that I do and that is in my purview, I can't say whether they have enough authority. What I can tell you is that in the case that you referenced that I worked on, there was a disagreement. The DC Circuit disagreed with the way I had analyzed the statute, and that sometimes happens, that judges disagree on statutory interpretations, and so they made the ruling that they made, and that's binding precedent now in our circuit for how that statute is to be interpreted.
Okay. All right, I have one other I will submit to you for writing, and it has to do with the number of reversals that you've had. But I see Senator Booker there, and Mr. Chairman, I thank you for the time.
Thank you very much, Senator Blackburn. Senator Booker, are you available by remote? I don't hear him.
I've been unmuted. Sorry, I was having trouble unmuting myself. I'm grateful for that. I'd like to just first make the case. It was said earlier in a equivalency that was a bit stunning to me about outside groups' influence on the picking of judges for the circuit and the in particular the Supreme Court. I want to just say that Joe Biden has said no such thing. In fact, he's directly refuted the questions about outside groups governing his decision. He understands that this is one of the civically sacred powers delineated to the President of the United States of America. And it's an executive power. And I'm sure he would feel that it would be a betrayal of that power to farm out responsibility for making choices to an organization, especially one that doesn't even necessarily align with his principles, his values for evaluating judges. That is dramatically different than what President Donald Trump, former President Donald Trump said, and I'll quote him. Trump promised that his judicial nominees would all be picked by the Federalist Society. He also said that he had turned to the, quote, Federalist people and to the Heritage Foundation to assemble his initial list of 21 potential Supreme Court nominees, which is basically saying that that sacrosanct power vested in the President of the United States was being turned over to an organizations that, yes, that should bring up questions for every senator. Who are these organizations? What are the money? What's the money and the interests behind them? Is it dark money? Is it folks with agendas that cut across the concerns that should be held by, in a bipartisan manner by members of Congress? This is a stunning departure from our national history, and farming out to such organizations should be abhorrent to everyone. And so I just wanted to make that distinction. To both of our nominees, it is an extraordinary honor to be sitting before you. This is a day that to me is worthy of celebration given your backgrounds, given the uniqueness of your careers. And I want to thank you both for being here. I talk often about issues of race and diversity. Those have been brought up by members on both sides. I just want to ask one question, and it's simply about another type of diversity that's just not talked about enough, which is the diversity of career paths. We just don't see that many on the higher courts of our land, people that are not ones necessarily having prosecutorial backgrounds, but people having time working as public defenders. This is an ideal that goes back to Adams representing British who were involved in the Boston Massacre, this belief that everyone deserves a defense. I think it is noble work, and I think it brings a much needed bit of diversity to our judicial system. In fact, an urgently needed level of diversity to have people from both career paths. And so I would just love for both of you, and then I'll take my answers off back on mute and turn it back over to the chairman. But for now, can each of you please maybe explain why it's important to you to have professional diversity on the federal bench when appellate judges are deliberating as a panel or as a full court? How does that diversity or professional experience help to really inform their decisions, in your opinion? And maybe a little bit about how each of your experiences as public defenders affect your opinions in and of themselves. And with that, I will go back on mute and thank the nominees in advance for their answers.
Thank you, Senator. I had the experience of working as a law clerk for two extraordinary appellate judges. I don't know yet. I hope to be confirmed and could see firsthand what the deliberation process is, but I do know that the judges meet and they discuss cases, and in that context, it seems to be quite typical for judges from all different backgrounds, prosecutors, people who have worked in private practice, people who have worked in other areas, to be able to contribute to the discussions about the cases. I sort of look at it from the Oliver Wendell Holmes view that the life of the law is not logic, it's experience. And so the more experiences that can be brought to bear on our complex legal problems, the better. I also know from my experience as a district judge that there have been changes in my own way of practicing, in my own way of interacting with defendants in my courtroom that are based on insights that I had from representing clients 16 years ago when I was an assistant federal public defender. And so you learn things. You learn things from experiences that relate to what you're doing in the judicial system, and they can be useful. in helping. And I told the story earlier just about the way in which I now communicate and forecast and lay out for defendants what is happening in cases. And I do that because I was aware as a defender of how many of my clients did not really understand the process, and that was detrimental to their rehabilitation. So I work on that communication aspect based on my insights from the time when I was a defender.
Senator Booker, I would only add that the Seventh Circuit has judges from many different backgrounds. There are state court judges who are now sitting on the Seventh Circuit, law professors, people who have been judges who have been prosecutors, attorneys for the executive branch. So I hope I would just add to that mix, because as I reflected earlier, and Judge Jackson also just referred to, that it's a collegial environment, and judges spend time discussing together their impressions of the cases in the effort to reach their individual opinions in a case. And so I hope that my background as a federal public defender, and frankly my background as a civil litigator as well, will help bring something to the table in the way that I know my colleagues' backgrounds already do.
Thank you, Senator Booker. Senator Cruz.
Thank you, Mr. Chairman. Congratulations to both of the nominees. Judge Jackson, you and I attended law school together.
We did, Senator.
It is good to see you.
Good to see you again.
Congratulations. Let me start with a general question to both of you, which is, how would you define judicial activism?
I think judicial activism is when a judge is unable or unwilling to separate out their own personal views of a circumstance or a case, and they rule consistent with those views rather than the law as they're required to do.
I would give the same answer, Senator Cruz, and also add, although judicial activism means many things to many different people, for me it also suggests a judge who goes outside beyond the issues presented to the court. Judges are limited, they have quite a restrained role in that they are to only decide the issues presented to them, and one form of activism is going beyond that.
So what should a principal judge do if the law requires one outcome and your own personal, political, policy views are to the contrary? How does a judge resolve that conflict?
Oh, absolutely. The judge is duty-bound to follow the law. The law is the binding principle that guides a case, and judges need to methodically separate out their personal views. When I rule in my cases, I look at the facts, the law, and the parties' arguments in the same way in every case, and I methodically apply only those inputs because I'm trying very hard not to look at this case through anything other than the prism of the binding precedents of the Supreme Court and the DC Circuit. And so absolutely, there's no question that a judge has to set aside their personal views about how a case comes out and rule only consistent with the law.
That's absolutely correct, Senator. The roles of advocate and judge are completely different, but in the same way as an advocate that I set aside my personal opinions about my clients and what they were accused of or what they were guilty of, I would also set aside, if confirmed, my personal views, my personal convictions, if any, because the law is what guides and should guide judicial decision-making.
What are both of your views on the notion of a living constitution and whether we have a living constitution?
Senator, I have not had any cases that have required me to develop a view on constitutional interpretation of text in the way that the Supreme Court has to do and has to have thought about the tools of interpretation. I am aware that the Supreme Court at least with respect to certain provisions of the Constitution that it has already interpreted, has looked at history and has focused on the original meaning of the text, say in the Second Amendment context in the Heller case. I just have not had any opportunity to do that. I have worked with those kinds of materials. When I was in private practice, I filed an amicus brief in which we argued using English common law about whether or not the English courts would have accepted evidence that had been extracted by torture.
So was this the amicus you did in the Boumediene case?
This was.
And was that pro bono representation?
That was. And I represented 20 former federal judges who wanted to make that point.
And what led you, look, with pro bono representation, that often reflects your own views. That's why frequently lawyers take it on. What led you to want to take that position?
Oh, I wasn't working alone. I was at a big law firm, and I was in their appellate division, and it was a client. It was a group of judges who I was assigned to work with as a part of that, my employment in the law firm.
But did you agree with the position you were advocating?
I was focused on my client's interest. I was doing what advocates do. I didn't have a personal view really of the issue other than just to make sure that I was making the most convincing argument that I could make on behalf of my clients.
So let me go back to the original question, which is, do you believe we have a living Constitution?
I believe that the Constitution is an enduring document. The Supreme Court has said a fixed meaning, that we're to look to the original words in the Constitution and interpret, as lower court judges, interpret provisions the way in which the Supreme Court does, and they look at the text and look at the original meaning. And so if I ever had one of those cases, that is how I would approach the task.
Ms. Jackson-Akiwumi?
Senator, thank you for the question. I don't find these phrases particularly useful. As a lawyer, a living Constitution is very similar to me, like judicial activism. It means so many different things to many different people. I do know the Supreme Court has not used those terms. I know that Chief Justice Marshall said that we have a Constitution that was meant to endure for ages, which it has, and to be adapted to the various crises of human affairs. And I think that is what has happened with our Constitution over the years. And beyond that, it's the supreme law of the land. And if confirmed, I would be bound by the Supreme Court's interpretations of the Constitution. It would not be my job to make law.
So if you could both tell me your view of the importance of the First Amendment, and in particular the protections of free speech and religious liberty.
Well, Senator, my view comports with the Supreme Court's view, because as a judge, I have to apply the doctrines of the Supreme Court. And it is very clear from the court's recent rulings, from the recent COVID cases, Trinity Lutheran, Masterpiece Cake Shop, and various others, that the court is looking into and is concerned about restrictions on religious liberty as a First Amendment principle. As well they should be, because the First Amendment includes religious freedom as a core constitutional right. So my views comport with what the Supreme Court has held about these things, and I would have to apply the Supreme Court's principles in any of my cases.
Ms. Jackson-Akiwumi?
I agree, Senator Cruz. The First Amendment is fundamental. It's foundational. All of the freedoms protected therein: speech, press, assembly, petitioning for redress, and religion.
Thank you.
Thanks, Senator Cruz. Senator Padilla?
Thank you, Mr. Chair.
Before I begin my questions, I want to take a moment to remark on the significance of this hearing. As Chairman Durbin reminded us and noted at the outset of this hearing, over the past 4 years, the prior administration appointed 226 judges to the federal courts, almost 30% of the current federal judiciary. An overwhelming majority of those appointees, 189, were white, and nearly as many, 171, were men. Over the course of the prior administration, our federal judiciary became markedly less diverse. Today marks an important step in reversing that trajectory and creating a federal judiciary that reflects the America that it serves. This committee has heard and will hear testimony from 5 nominees, all persons of color, and 3 women. They have experience in public defense, prosecution, civil litigation, municipal law, and military service. The diversity of background and professional experience they offer to the federal judiciary, in addition to their impressive qualifications, is remarkable and important. So I hope, Mr. Chair, and expect that this will be only the first of many such nomination hearings this Congress. Now to my questions. The first for Ms. Jackson. If confirmed, you'll be one of the few former public defenders to serve in this capacity. So can you take just a minute to speak to the role and importance of public defenders to our criminal justice system?
Senator, did you mean Ms. Jackson?
Yes, Jackson-Akiwumi.
Yes, thank you.
Yes, I'm sorry.
Thank you, Senator Padilla. It's foundational. The Sixth Amendment guarantees the right to assistance of counsel, and the Supreme Court has interpreted in that the right to counsel in criminal cases when one cannot afford an attorney. This is important because the integrity of our system depends on it. Judges make the best decisions when they're presented with the best arguments from both sides. And due process guarantees that people be represented and have the opportunity to be heard, regardless of their ability to pay. So it was my honor and privilege to work within that system for a decade to ensure that my clients were competently represented, regardless of their ability to pay, and frankly, regardless of what they were accused of, and to help our country live up to its constitutional values.
Great. And just a follow-on, earlier in your career, you spent about 3 years working at a corporate law firm with, I'm sure, very nice offices and a lot of resources and high salaries, but you chose to leave that very comfortable path to spend the next decade of your career as a public defender. Just for a minute, just for a moment to reflect on what would prompt you to make such a change.
Well, Senator, I am very grateful for the 3 years I spent litigating at Skadden Arps. It was a tremendous experience representing our clients, which ranged from corporations to nonprofit organizations, individuals. I gained a lot of experience, tried my first jury trial, argued my first case before the Seventh Circuit Court of Appeals, before which I appeared many times after that as a federal public defender. But I always knew that I wanted to return to public service. I began my legal career serving the public as a law clerk to 2 federal judges, and I wanted to spend the bulk of my career that way. And this nomination by the president has given me an opportunity to yet again serve the public if this committee and the Senate as a whole so decides.
Thank you. My next question for Ms. Brown Jackson.
Thank you.
In the 8 years you've served as a district court judge, you've presided over hundreds of cases. In that time, you have ruled for both prosecutors and criminal defendants, for workers and employers, for the government and those challenging governmental decisions. Is there an ideology or philosophy that guides your approach to judicial decision-making, and how do you that changing, if at all, if you're confirmed to the circuit court?
Thank you for that question, Senator. Not really a philosophy, more of a methodology. It is the idea that it is only appropriate for the judge to take into account the arguments of the parties, the facts in the case, and the law that applies in every case. And I have found that if you do that, you can be consistent in the way that you're analyzing the issues, and you can set aside any thoughts about who is making the arguments, what advantages any side might take away from your opinions. If you have a fidelity to the rule of law that is grounded in looking at only those inputs, then I think you can rule without fear or favor, which is what I've attempted to do.
I want to, as some of my colleagues have already done, thank you both for your willingness to serve, and thank your families for supporting your service, because I know it's not easy. But in the last minute I have left, ask you both to briefly comment on what it just means to you personally, for you and for your family, for you to be here with this opportunity before you.
Well, Senator, I am fortunate enough to have an office now that is just a few blocks from the National Archives. And sometimes I go there and I reflect on the momentousness of my duties and the fact that I've had an opportunity that my grandparents would not have been able to even fathom. And it is the beauty and the majesty of this country that someone who comes from a background like mine could find herself in this position. And so I'm just enormously grateful to have this opportunity to be a part of the law in this way. And I'm truly thankful for the president's giving me the honor of this nomination.
Thank you.
Senator Padilla, I share a similar sentiment. I am the granddaughter of a sharecropper. 3 of my 4 grandparents had only a 4th and 6th grade education. But I also grew up with the precept, to whom much is given, much is required. And despite those humble beginnings, my family has always been one that valued education, and I have been given a top-notch education and top-notch experiences that I'm so grateful for. And I recall Attorney General Garland telling you all that he believed it was the highest and best use of his skills to be able to serve the country in this way now. And although I've not been a circuit judge, and I'm certainly not the Attorney General, I agree with Attorney General Garland in this moment now to serve as a circuit judge at the request of our president would be the highest and best use of the skills that I have, and such a way to thank my family and this country for the many opportunities that I have been given.
So, well, as proud son of immigrants from Mexico with little formal education, but a work ethic that led to 40 years working as a short order cook and a domestic worker who had an opportunity to study at the Massachusetts Institute of Technology, earn a degree, and years later gets to sit on this side of the dais. I thank you both.
Thank you.
Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Kennedy.
Thank you, Mr. Chairman. Judge, Counselor, welcome. Counselor, let me start with just a few general questions. Can you give me your thoughts about the meaning and the importance, if you think it's important, of the adequate and independent state ground doctrine, which you'll probably see a lot on the Court of Appeal?
Sure, Senator Kennedy. It's actually a doctrine of the Supreme Court that governs when a case presents federal grounds. But if there's also an independent and adequate state court ground that supports the decision, the Supreme Court will not choose to take the case. So the Supreme Court is the body that has the ability to exercise that doctrine. The Seventh Circuit Court of Appeals, if I am confirmed to it, would not have that opportunity because, as you know, the Court of Appeals takes every case that's appealed to it. It doesn't have the ability, like the Supreme Court does, to pick and choose which cases it will hear.
So you're saying that the Seventh Circuit can't decide a case or invoke the adequate and independent state ground doctrine?
Senator, there are other abstention doctrines that would govern if the Seventh Circuit, if a panel felt that there were state court questions that needed to be resolved, so the federal case should hold off for a bit, or if there was an independent state court ground for the case that necessitated a particular type of ruling, but it wouldn't, that doctrine would not cause the Seventh Circuit to not take the case to begin with. The Seventh Circuit has to consider the appeal and then issue a decision, yes.
Right. But you're not saying that the adequate and independent state ground doctrine is not applicable to the Seventh Circuit, are you?
I'm saying that's a doctrine of the Supreme Court, and the Seventh Circuit has other doctrines.
It's a doctrine of the Court of Appeals too, isn't it?
My understanding, and I will tell you, Senator Kennedy, that this is not an area I've been litigating in the last 16 years, but this is my broad understanding that it's a doctrine of the Supreme Court.
Okay. What is your definition of justice?
Thank you for the question, Senator Kennedy. Emblazoned on the Supreme Court across the street is equal justice under law. I marry that with the ethical canons and codes of conduct that apply to judges. And one of them includes treating all parties fairly and impartially, and acting with diligence and upholding the independence of the court. And I think when you marry all of those concepts together, then you arrive at hopefully what is justice for the parties who come before a court.
Counselor, do you believe that that crime is a disease that needs a cure, or is it antisocial behavior that deserves punishment?
Senator Kennedy, neither of those options are words I've ever used to describe crime, which has been my province for the last 10 years, representing people accused of crime and who have pled guilty to crime. If there's anything that my decade as a public defender taught me, is how gray everything is. And how there's often a faint line, an indescribable line, sometimes a complicated line, from when someone goes from being law-abiding to breaking a law, and all the reasons why that happens, and all the different ways we as a society can address that. And I hope to bring that nuanced understanding with me to the circuit court if confirmed. I will be guided by the law and have to apply the law, and would willingly do that to the facts of any different case. But I think that nuanced understanding will enhance my ability to understand the facts of any given case.
Okay. Are you a textualist or a proposivist?
Thank you, Senator Kennedy. One of the things that I expressed to your colleague who asked a question earlier about a living constitution, and there was yet another question about judicial activism, is that I don't find these labels particularly helpful. They mean so many things to so many different people. What we do know is that the Supreme Court has instructed us that one must first.
Actually, Counsel, I think they're pretty standard definitions. Can you tell me which way you lean?
No, Senator. The Supreme Court has instructed that one must first look to the text of the Constitution, the plain meaning there, also the plain meaning of the text of a statute. And so that method, the Supreme Court has instructed judges what to do.
Counselor?
Yes.
I'm sorry to interrupt you, but my chairman's very strict on me, and I do want to get to ask the judge one question in my 35 seconds, and I'm sorry to interrupt you. Judge, you've been on the bench, and you've seen the federal judicial system up close, and I agree with you, America's a remarkable country. Do you think the federal judicial system is systemically racist?
Senator, thank you for that question. I am aware of social science research.
I'm sorry, I couldn't hear you.
I'm aware of social science research.
Yes, ma'am.
In particular, in my former area of expertise, which is in sentencing, that relates to ways in which policy choices about various aspects of the system can have demographic disparate effects. The most obvious one is one that this body has worked on very hard and much appreciated, the 100-to-1 crack powder disparity. As a judge, I am not looking at systemic effects. I'm not thinking about or focusing on or forming opinions about the research or the circumstances in the abstract like that. I am looking at each case. A person might make a claim that they've been discriminated against in a particular context, and I am applying the law to determine whether or not the law sustains that claim. So I don't really have a frame of reference to answer a question about systemic racism, but I am happy that you are thinking about those things because they're in the province of the policymakers like yourself.
Okay. Thank you, Mr. Chairman.
Thank you, Senator Kennedy, and I would like to thank our two circuit court nominees for your patience, your endurance. Please be mindful that, as you've heard, senators may submit written questions following the hearing. We'd ask you to diligently respond as they are sent your way. I'm going to excuse this panel, and just in time, in the nick of time, comes the senator from New Jersey. Have you voted?
Yes, sir.
Good. Come right on up here, because I haven't. And thank you to this panel, and I'm going to ask the senator from New Jersey to convene the second panel and prepare them for testimony. And I will return briefly.
Can I ask the nominees to take their seats? I am actually going to swear them in first. Yes, so forgive me. So you all were right in standing up and staying there. This is a long time since I had Julian Niels telling me what to do every day. And Julian will remember I'm usually swearing at him, but now I will swear him in. Would you please raise your right hand and repeat after me, and answer this question? Do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. You may take your seats. And why don't we proceed with the testimony? We'll start with the Honorable Julian Niels.
Seem to be having some technical, oh, is it on? Oh, thank you. First off, Senator, I would just like to thank Chairman Durbin and Ranking Member Grassley, and sincerely thank the committee for today's hearing. And thank you to you and also to Senator Menendez for that more than generous introduction. Thank you also to both of you for submitting my name to President Biden, and my thanks to President Biden for this nomination. I offer congratulations to my co-nominees. It's truly an honor to share this experience with both of them. And I owe a debt of gratitude for even reaching this point in this process, and also to those who are with me today. My father, World War II veteran and retired administrative law judge, Felix Niels. My mother, retired teacher, poet, and actress, Betty Niels. Their unending energy, encouragement, love, and support have carried me to this point in my life and career. My sister's also with me, college professor, world traveler, Felice Niels, whose fearless, adventurous spirit has always been an inspiration to me. My dearly beloved wife, Lauren Jones Niels, who's been a grounding, loving force in my life since my second year of law school. Our son, Julian Keith, couldn't be here, but he brings us love and perspective, and he is finishing up finals at Keene University, and unfortunately had to spend his senior year remote with his parents. Also in attendance is Anna Pereira, a tremendous former fellow judge and corporation counsel colleague from the city of Newark, and Arvelise Gonzalez-Merle, my assistant of 25 years, which in and of itself proves her saintly qualities. My brother Felix, who was watching from Washington State, he's been the best big brother anyone could ask for. And I send love, warm greetings, and thanks to family, the incredible professionals with whom I've worked at the firm of Chasen, Lehner, Mallon, and Campuzzo, the great city of Newark, and the great county of Bergen, and to the many friends and professionals who have wished me luck in our watching. Finally, a special 21-year-old birthday wish to Julia Pessers. Thank you, sir.
Thank you very, very much. We will now go on to Judge Qureshi. You may also make your opening remarks.
Thank you, Senator Booker. I'd first also like to thank Chairman Durbin and Ranking Member Grassley for scheduling the hearing for today, and also thank the members of this committee for taking the time to consider my nomination. I'd also like to thank, of course, the President for nominating me, and also my home state senators, both Senator Booker and Senator Menendez, for their consideration, recommendation, and support of my nomination. I share Mr. Niels, or Judge Niels' comments. Thank you, Senator Booker, for your kind introductory remarks from earlier today. I have a few folks with me that I'd like to introduce. First, my mother, Zahid Qureshi, is here. I don't have enough time, Senator, to properly introduce my mother. What I will tell you is that when I asked if she would like to attend today's hearing, she said she would walk from New Jersey if needed. So I hope that gives you some context for the love and bond that I have with my mother. Unfortunately, I'd like to mention my father, Dr. Nisar Qureshi. Unfortunately, my father cannot be here today. He tragically passed away last year to the COVID-19 virus. I know he would have been very proud to be here, sitting alongside my mother behind me, and I feel his presence today in this room. I'd also like to thank and introduce Jenny Chung and Levar Tan, two individuals very close to me who were especially supportive of my nomination and supportive of me throughout this process. And they were kind enough to accompany both me and my mother here today, and I'm grateful to have them. Lastly, Senator, I'd like to just address my children who are back home in New Jersey, hopefully in class, but I have a feeling they are trying to log into the video link to today's hearing. My daughter Zoe and my son Aiden, who I love very much. I've said this before publicly and privately. I've held many titles and many roles in my life. The one that means the most to me in my life is that of being their father. So I'm grateful for the two of them, although they could not be here today. Senator, thank you for indulging me. It's an honor to appear before this committee with my friend Julien, Neals, and Regina Rodriguez from Colorado, and I welcome the opportunity to answer any questions you may have regarding my qualifications.
Thank you very much, Judge Qureshi. Ms. Rodriguez, would you please give us your opening statement?
Thank you, Senator. It's my pleasure to be here with you today, and I also wish to extend my thank you to Chairman Durbin, Ranking Member Grassley, and members of the committee. I appreciate you holding this hearing to consider our nominations, and I congratulate my fellow nominees today. Thank you to President Biden for the honor of this nomination, and a very warm thank you to Senators Bennett and Hickenlooper for the confidence they have placed in me. It is very humbling. I also thank former President Obama and Senator Gardner for their support of my prior nomination. I want to introduce to you now the Colorado contingent, also known as my family. Very proud to have them here with me today. My husband and my partner, Arnold, in what will be 20 years of marriage in the next couple of days, neither of us imagined that our journey would lead us here, but we are very grateful to be here. My daughter, Naya, who is a high school senior this year, her resilience and fortitude in this unusual year has been inspiring. My son, Miles, who always makes us proud in his feats in the classroom as well as on the football and basketball fields. My mother, Linda Rodriguez, that you've heard some about, her story is a journey in and of itself. My sister, Marla, who works for 9 Health in Colorado, and her husband, Noel Willis, who works for Denver Water. There are many people who have supported and championed me to bring me to this moment. Too many to mention by name, but you know who you are, and I thank you so much. Thank you again for this honor, Senator, and I look forward to the members' questions.
Well, you all got me a little verklempt with your families there. What extraordinary people you have behind you, and the journey to this moment for each of you is extraordinary, but it's a tribute to the nation that we all love. You are sitting before the Judiciary Committee of the United States of America's Senate, and it's a wonderful opportunity. Even though you don't see a full cavalcade of senators on both sides of the aisle, I want you to know that this part of the process, as spelled out by the Constitution of the United States, is a sacred part of the process. And as you all sit before us, I'm sure there will be questions for the record that you will all ask to be completing. But for now, until the chairman comes back, I have the gavel, I have the power. Let's have some fun. I'll first turn my questioning towards Julian Niels and ask him, in his 20 years of working with me, would he please go over in detail my finer points as a leader? No, in all seriousness, I'd like to direct the first question to Judge Qureshi. You've dedicated the vast majority of your professional life to serving your country. That says a lot.
You worked in the JAG Corps, the U.S. Department of Homeland Security, the U.S. Attorney's Office for the District of New Jersey, and now as a U.S. Magistrate Judge. You had a lot of other lucrative opportunities before you. And I was wondering if you could tell us why you are so passionate about public service and why you believe these experiences have really prepared you for the role as an Article III District Court Judge.
Thank you, Senator Booker. As you may recall, we refer in New Jersey to the folks that practice in federal court as our federal family. That involves not only the judges and the court staff, but it involves prosecutors, federal public defenders, civil practitioners in the federal bar. I think for me, in my career, I have felt a part of that federal family and being a member of that federal family before I even knew what it was. I think that stemmed early in my career in the military. When I was honorably discharged and was returning home to New Jersey after military service, I was looking to find some civilian equivalent of what I'd felt when I was serving in the Army, being a part of something larger than myself. And that, to me, was public service in the federal government, with the Department of Homeland Security, followed by the United States Attorney's Office, and even in the private sector, supporting programs like the Reentry Court and the Judicial Conference and other programs for our federal court. As far as my collective experience, I think it will be useful as a district judge. I think having the experience of being both a prosecutor and a defense lawyer, as a veteran, as a practitioner, a private lawyer, working at a law firm, and currently sitting as the United States Magistrate Judge, where I'm handling civil cases and some of the criminal duties of a magistrate judge. I think collectively all of that will benefit me if I was so fortunate to be confirmed as a district judge.
I'm really grateful for that. I can't help but mark the significance of your faith. If you're confirmed, as has been said multiple times already, you'll be the first Muslim to serve as an Article III federal judge. In my opinion, it goes without saying that this should have happened a very long time ago. There were Muslim Americans here at the founding of our country and have played a role in everything from arts, business, invention, in so many areas of American life, but not on the bench at the federal level. And I'm wondering, as we now see us break this extraordinary milestone, I just wonder if you might tell us what you're thinking and how it feels to be a trailblazer, a glass ceiling breaker, and a history maker.
Thank you, Senator. You know, I've thought a little bit about that only because I don't identify myself in any particular way through this nomination process, but I've obviously read that I would be the first Muslim American Article III judge if confirmed. Candidly, I would prefer to have been the 100th or the 1,000th, not the first, but I understand that it comes with a lot of responsibility. Senator, as you know, I was the first Asian American to sit on the district court in our state. In our state's history on the federal court. And I understand what that means to the community. I can tell you that if confirmed, I would approach this historical nomination the same way I approached being the first Asian American on the New Jersey District Court, and that would be to put my head down, do the work that's before me on the court to help my colleagues and the Article III judges that are overwhelmed with a significant caseload and 6 vacancies, and to serve by example. And I think you said it better than I could, Senator, that if I'm so fortunate to be confirmed to be the first, the goal is for me not to be the last. And so that's how I would approach it.
I'm grateful. I am in full recognition that I have tumbled from the high height of being chairman of the Judiciary Committee back down to being the junior senator from New Jersey. And so my time has expired, even though I have some more questions for Julian Niels, perhaps on a second round if the chairman now would so allow it, but I will yield to the senior senator from the state of Illinois and the chairman of this committee.
Thank you very much, Senator Booker. I hurried back because I wanted to see if Mr. Niels had a halo after the initial introduction by Senator Booker. I was anxious to see you look like a perfectly fine, normal human being. and he has given you sanctified, miraculous qualities. I thank you for being here. It is such a refreshing experience here to have candidates for lifetime appointments to the federal judiciary who've actually been in a courtroom. In the last 4 years, that was not always the case. We had many nominees brought before us who may have watched the first part of NCIS on television, but that was as close as it ever came to a courtroom experience. And so I don't have to ask you, sir, in terms of 6,000 cases, was that the number that you were involved in with the municipal court?
Yes, Senator.
What kind of cases?
Thank you, Senator, for the question. The Newark Municipal Court is composed of 11 full-time judges and a staff of 104, and hears approximately 500,000 cases a year. And those range from disorderly persons offenses to landlord-tenant cases to truancy cases and other regulatory code violation cases. Traffic is also a significant portion of that as well. And while I was sitting as chief, I would cover the courts for other judges in their absence. So I had the opportunity to sit on all those different types of cases during my tenure.
That's real courtroom experience. There's no question about that. Mr. Qureshi, you too have had quite a background in the law on the military side and civil criminal side as well. I'm going to follow up with a question which I'm almost embarrassed to ask, but only because I've heard it from other members of this committee from time to time, and it's likely to come up at some point. What do you know about Sharia law?
I don't know anything about that, Chairman. If the question, too, is whether I would apply the laws of the United States in the state of New Jersey, I can tell you in 21 years of practicing law as a federal prosecutor, as a military officer in the United States Army, as a defense attorney and partner at a prestigious law firm in New Jersey, and a United States magistrate judge, I've never even been asked the question. That being said, I know probably less about it than you do, and I don't know anything about it.
Good. Not good, but certainly we're anticipating criticism which has no basis in fact because things we've heard. Your answer is solid. Ms. Rodriguez, gosh, what a journey your family has taken over the years. It's amazing to hear the story. I don't know if I'm repeating something that was raised earlier about your going out and knocking on doors to try to find a lawyer. Have you told that story here before the committee?
I have not, Senator.
Would you please?
Certainly. I was a senior in high school, living in Macomb, Illinois at the time, and I had an idea that I might want to be a lawyer one day, but I didn't know any lawyers, and I didn't really know what all that involved. So in my rather naive 17-year-old way, I put on my best suit, and I started going from door to door to lawyers' offices in our town of Macomb. And most did not see me. Many people seemed very surprised that this young woman would show up at their doorsteps. And most explained that you had to at least have had 1 year of law school before you could get a job in a lawyer's office. And I found one person, his name was John Bisbee. He was a civil rights lawyer and a criminal defense lawyer. And he said to me, "You want to do what?" And I said, "Well, I thought I should work in a law office to understand what lawyers do." And he hired me. I spent the summer serving subpoenas, helping to create a brief bank, and helping him in the ways that a young person could do in his law office. And that really was the start that I got.
Is he still around?
Unfortunately, he's passed away. I did try to find him.
That's a great story.
Yeah.
Great story about you and about him. And I'm glad it happened in Illinois. It makes me feel good about it. It's been a long time since I've been in a federal courtroom as a lawyer, practicing lawyer, and I will tell you that the temperament of the judge had as much to do with my experience in that courtroom as any law or facts that I brought before them. I want to say a word about temperament of a judge before people who come searching for justice. Ms. Rodriguez?
Yes, thank you for that question, Senator. I too share the belief that the temperament of the judge is very important. It certainly has shaped my experience in the many courtrooms that I've been in, but even more importantly, it shaped the experience of the people who appear before those judges seeking justice. And fundamentally, that's what all of our jobs are when we enter into a federal courtroom, or any courtroom for that matter. It is critical that the judge listen intently and provide every person who appears before him or her with a fair opportunity to be heard. I believe we heard the nominees for the circuit court talk about the importance of listening and hearing what parties have to present, and them having the experience of being heard. I agree with that wholeheartedly, and that would be my goal should I be honored with a confirmation for this position.
Thank you. Mr. Qureshi, what is your experience?
Thank you, Chairman Durban. I can tell you, and I don't know if this is a popular answer, but I like lawyers. I was a practicing lawyer for most of my career. Many of my friends, members of the bar, mentors that I've looked up to in my career before serving on the bench are all folks that appear in our district court in New Jersey. So for me, it's seeing a reflection of myself when somebody walks into the courtroom to appear before me as a magistrate judge. I think they're me. I would hope that I would bring that same thoughtfulness and respect and mutual respect that I brought as a United States magistrate judge. I hope to bring that if I was fortunate to be confirmed as a United States District Judge, Chairman.
And the sanctified Mr. Niels?
Thank you, Senator. I have to say that in my time as practice, I had a very deep understanding and appreciation for judicial temperament, just in terms of being able to get your case heard and get your case processed. My time as Chief Judge, however, with Newark Municipal Court gave me a whole different appreciation of the importance of judicial temperament. For most people, their experience in court is a very intimidating one. And it became very clear to me that, especially from the litigant's perspective, it's very important that they feel that their case is going to be heard. They're going to have the opportunity to tell their story. They're going to understand the proceedings, and they're going to understand the result. And the judge is the one who sets that tone. So I think it's just important to have calm demeanor, open-mindedness, and you show your appreciation for the fact that this is such an important event in most people's lives. But I also think that that temperament has to also be reflected in how you deal with the attorneys, with your court staff, and the public in general.
Thank you. I have no further questions.
Chairman, I appreciate you allowing me. May I continue for a few moments? Thank you, sir. This is, everything you say here is for the record and under oath. And I just imagine as systems get better digitized, your testimony here could be looked at by future generations. And I would imagine that perhaps one day somebody from your lineage will look back to listen to what you had to say today. And so, Mr. Qureshi, your father died of COVID and recently. I remember how I felt when I came to this institution days after my dad had died to become a United States Senator. I was wondering, for the record and for the future, could you just tell us about your dad's influence on you and how that influence helped to make you, would help to make you a better judge?
Sure, Senator. It's a difficult question, and I've been prepared for many questions today, but not this one. My father and I were very close. He was a significant influence in my life. You know, I remember speaking to a room of maybe 400 lawyers at my investiture ceremony almost 2 years ago and told them that in a room full of federal judges and the best practitioners in the state, my first advisor, if I ever needed anything, would be my father, and that was true. He grew to be a close friend, but also a counselor to me. And candidly, he was my first influence in how I even went to law school. You know, like some or many Pakistani fathers, I think my father early on thought that I would go to medical school. it was not in the cards for me. I was not into science. I was not into medicine. And I remember when I was considering a career in law enforcement, it was my father who first suggested, why don't you consider law school, get your degree, your Juris Doctorate, and after you're done, you can consider, what you want to do next. And if it's a career in law enforcement, that won't have escaped you because you went to school for another 3 years. And so it was my father's initial advice, along with my mother, that supported me going to law school. As far as who I am today, I'll tell you, frankly, Senator, if I'm half the man my father was before he passed away, I've been a success in my life. His loss was tragic to my family, to my mother, and what I hope to do and what I strive to do for my children, who are very fond of their grandfather as well, is do the best I can, treat everybody with respect, be kind to others, and hope that he will be proud of the man that I am, which he was before he passed away, and that the man that I'll continue to be.
I'm grateful for that. Just one more question for each of the nominees, and then this experience, I hope, will be coming to a conclusion. But Ms. Rodriguez, I'm sorry, I did not plan to answer this question, but you piqued my curiosity. And again, with the same sort of caveat that you're speaking to the future, behind you is an extraordinary woman that you said has an incredible story. Could you tell us a little bit more about your mother and her influence on you in being here today?
Thank you for that question, Senator. It's the generation of women in my family, starting with my grandmother, Mary Takahashi. Her Japanese name is Yoneko. My daughter is named after her, Naya Yoneko. They had a business, they had a life in California, and when the internment order came, they were ordered to gather their belongings into what they could carry in suitcases, and they didn't know where they were going. My mother was very young, and her brother as well. I think of the fact of our families, how much we love our children and how we try to protect them, and what it would be like to be told all of a sudden that you were going to leave your home and carry only what you could carry with you for your children. They were put on a train to Wyoming, and that is where they remained for a number of years. What's interesting to me is that my family never really talked about the internment and the hardships they endured, which there were many. What they talked about was the friends they made, the people they knew, and the opportunities that now this country has given. After the internment, my grandmother had heard that there was still discrimination against Japanese in California, but she had heard that the governor in Colorado was welcoming. And so they moved the family to Colorado in Denver. And that has been the beginning of the legacy there. My parents met in Gunnison, Colorado, and my father hails as well. And I appreciate just a moment to also mention my father, who passed away just a few years ago. He did grow up in a boxcar in what he calls the south side of Chicago, although I think he thinks that that is a little elevated for where he actually was. But he grew up without running water or electricity. But both of my parents made their way to school. And that's really what's given them their start and what's given me my start. And so I am eternally grateful for that. And it means that now it's my opportunity to once again return to public service and give back.
I'm very grateful for that. What extraordinary American stories both of these last two witnesses who spoke have. And it's just a testimony to what I think so many of us love about our country, that we are this nation of the highest ideals of humanity that bring together all of humanity in this diverse tapestry that makes us all better from our whole. I want to just end with Julian Niels, and I'll say to my senior colleague that if any sanctification that I'm doing, trust me, it was earned through some of the most difficult years of my life, trying to govern a city in a global recession. I had these moments, though, that I cherished, is when I
first made Julian Neals my chief judge. That same family you see behind there would gather together with incredible pride. I then made him my corporation counsel, and I saw the same gathering of family. Then he became the leader of the city, really the person that did the day-to-day work, trying to get our city out of a deep ditch, and managed to do it in a way that not only got us to fix fiscal strength, but the biggest parks expansion in a century in our city, brought supermarkets, our first hotels in decades, first office towers in generations, doubled the production of affordable housing. This man found ways to make a way out of no way and take a city that many people wanted to cast aside, look down upon. He made us stand up with pride. But there's nothing like the pride of his family. And I hope you get a chance, Mr. Chairman, to walk over there, because his father is one of the more dapper men that I've met, and reflects the dignity that his son has, and his mom is just an extraordinary woman that beams light. And so I just want to end by saying, Julian, we've gone through this a lot, never before on a national stage at a federal level, and I would just want to tell you that I know you are the man that you are because of the parents that you had, and would you just please say, for the record and for eternity, some words about them, and then I am done, Mr. Chairman.
Thank you, Senator. The influence that my parents have had is immeasurable. My father was born in 1929 in Florida, and imagining the experiences that he has gone through to have matriculated here, to have eventually become an attorney and eventually become a judge, is just remarkable. My mother, the pride that she has had in being a Norker, and her words that would resound of how important it was for her that her children would have that same experience, that they would have a rooting and a relationship with this substance of that cultural experience and what that city fought to overcome. And honestly, when it was my distinct honor to serve with you in Newark, it was hearing words of what your vision was for Newark that resounded against what my mother had told me. And I knew at that point that public service was the right direction for me. And with both of them being retired public servants, I realized the value of giving back, and I realized the sacrifices that they have made and the life pursuits that they have done in raising 3 children in what often were many difficult times, putting through private school and supporting them even to this day. So I really appreciate the opportunity, Senator, to have given that recognition to my parents and just the experience and the support that they've given me. And I thank you as well for this opportunity.
Thank you, Mr. Chairman.
Thank you very much. And I've come to know Senator Booker in his Senate career, and I would say, Mr. Niels, that if you could cover him with glory, you are truly a talented man and destined for great things. And I hope that, and I believe that will include the federal bench. I thank you for being here, and especially for your family continuing to back you up. Mr. Quraishi, and the story you told about your father was touching, and I want to thank you as well for being a person to make history in America. That's saying something, and it's something I'm sure you'll be very proud of. Ms. Rodriguez, I'm glad you stopped in Macomb, Illinois for some inspiration in part of your life's journey, and what a remarkable story on your family as well. So before I adjourn today's hearings, I want to enter a number of letters in the record and make a few logistical notes. We've received letters of support. The letter I referenced in my opening statement from Judge Thomas Griffith in support of Judge Jackson, a letter in support of Ms. Jackson-Akiwumi from 134 lawyers practicing in the Northern District of Illinois, including 4 former U.S. attorneys. Another letter supporting Ms. Jackson-Akiwumi from 90 attorneys in the Chicago area who worked with the nominee and served as opposing counsel, and many, many, many letters in support of our exceptional district court nominees. I'll enter all these letters into the record, as Senator Booker said, for future generations or anyone to see. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, May 5th. The record will likewise remain open until that time to submit letters and similar materials. And with that, the hearing is adjourned. Thank you.